Anything? Yes. Any mention? Please be fast.
Lordship, I beg to mention item number 7.
Your Lordship, this matter was heard.
Your Lordship, in this matter, I supposed to.
Then your Lordship has come to conclusion that some records is required.
So record Your Lordship I have to collect, so it requires some time.
What is the matter about?
This is a
Regarding
matter with
this-
regard to the ACR,
ACR.
Your Lordship.
Oh, yeah.
And then he was superseded. Thereafter, directions of this court sent it back to the department to furnish the ACRs. Thereafter, they came back to the same conclusion, but the only irony is that the finding was that if I am granted promotion, it will create a floodgate to other people. That was the only ground of my rejection for promotion.
It is not like that, Your Lordship. This is given that if it is given in such a way, that's review and review systems will be given the floodgate. So this is the not as regard to the promotion.
But that is the finding in the order, Your Lordship.
So now you're supposed to produce the record.
Your Lordship, I have to collect the record and there is some communication there.
How long?
2 weeks.
Mr. R. Devnath, Leonard CGC has submitted that records that the records supposed to be produced before this court today could not be done so, and as such has sought for completion for the day. On this prayer not being objected to by petitioner, matter is adjourned. This is here for 2 weeks.
Obliged.
May it please your Lordship. Lordship, I beg to mention for listing of an anticipatory bail, Lordship. This matter may be listed today, Lordship.
Why today?
Lordship, there is an urgency also, Lordship.
What is the urgency?
Yesterday we have filed.
Your file is today.
Yes, Lordship.
It will come up tomorrow then.
Okay, Lordship,
Let it come up tomorrow.
it will be convenient for us, if Lordship, if allow today.
What's the urgency? What is the seriousness of the?
If notice has been served by the police under section 41A,
Then,
and he could not appear before the.
what is there?
Okay, Lordship,
It's
tomorrow.
only a notice under 41A.
Tomorrow, Lordship.
We'll take it up. You just acquire from the registry.
Yes. Okay. Okay, Lordship.
Please, Your Lordship, I beg to mention item number 5. Your Lordship, we are praying for 2 weeks' time.
You are paying for?
2 weeks' time, Your Lordship.
Who you are paying for?
For the petitioner, Your Lordship.
This is a 2017 matter.
I know, Lordship.
No adjournment.
Your Lordship, my senior is only unsanctioned leave, Your Lordship.
Maybe on sanction leave. It's his duty to ensure that somebody represents the matter. You are there. You must will take it up. What is the matter about?
It's MPSC matter, Your Lordship.
PSC matter?
MPSC, yes, Lordship.
Your Lordship, we've been working in this course of lecturer now for the past 8 years. After we were selected, now they failed to qualify in the examinations. Now they've taken a U-turn, challenging the selection process, challenging also the expert committee, who has been teaching in the subject of in the subject of Garo now for the past 30 years.
Is that the interview board,
Yes,
constitution of the interview board?
Your Lordship.
Yes, Your Lordship.
But,
Expert member.
Tura,
And another thing also is that the selected candidates have been appointed.
We've been working now for the past 8 years, Your Lordship.
8 years now.
We're settled in this particular post.
we'll see if equity is in your favor. On pre-made by the petitioner, this is matter of the 2 weeks.
Your Lordship, similar prayer on item number 8.
Number?
Number 8, Your Lordship.
On
As
pre-made by
per the last order, we have already filed the written argument today.
you are for?
Written argument.
You are for whom?
I'm for the petitioner.
Oh, and you are for?
Respondent number 1 and 2, Your Lordship.
You have filed your written argument?
Yes, Lordship,
You have
today.
not filed.
But as per the last order, Lordship. But we have already submitted that.
On pre-made by the petitioner respondents, this is matter of the 2 weeks.
Obviously.
Please, Your Lordship, I beg to mention item 11. Item 11.
Yes, who's appealing?
I've already informed the state respondent, Your Lordship. 11. I've already informed Ma'am Colleen.
On pre-made by the petitioner, this is matter of the 2 weeks.
Highly pledged.
Please, Your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship.
13.
I pray this matter may be listed after 3 weeks, Your Lordship.
Yes, Lordship.
On pre-made by the respondent, not objected to by petitioner. Matter is adjourned. This is same after 3 weeks.
Highly obliged, Your Lordship.
Excuse me.
Please, Lordship. Lordship, I beg to mention item number 14, Lordship.
I'm for the petitioner.
What is this matter about?
Lordship is quashing of POCSO matter, Lordship.
Watching POCSO?
Lordship.
What is the stage of the case?
Stage of evidence, Your Lordship.
Evidence.
Lordship, status report is received, Lordship, and
How many witnesses?
No witness has been examined.
So you want the matter to be adjourned?
Lordship, I'm yet to get any judgments on this case, Lordship. Factually, but I just need some more time to get some judgments on this case, Lordship.
Mr. H. Karwanlang, Leonard, additional senior GA, appearing for the state respondent, has sought for accommodation on the ground that he is not prepared for the hearing today. Prayer not be objected to by petitioner. Matters adjourned. This is the same author.
Also after 2 weeks.
2 weeks. 2 weeks.
Please, Your Lordship. Lordship, I beg to make a mention item 12. Lordship, I'm praying for 1 week accommodation, Your Lordship, in this matter.
No objections.
On pre-made petitioner, this is matter up to 2 weeks.
Highly obliged, Your Lordship.
From supplementary course list, item number 1.
May please, Your Lordship.
Swallow the
May please, Your Lordship. Lordship, this is an application for grant of bail, my lord, to the accused person, filed by the petitioner, who is the cousin brother of the accused person, my lord. This is also in pursuance to the matter which was moved before Your Lordship day before yesterday regarding a incident of a fight and a lighting of a vehicle in the border districts of Southwest Garo Hills, my lord. The plea taken, my lord, was that it appears that there was a fight because of the two political rivalry. Now here, my lord, the accused person here is the person who has been named in the FIR, one Silnang CH Marak, and it has been alleged, my lord, that he has assaulted the alleged victim and set fire to the vehicle. Lordship, this incident occurred on 16th of March 2024. Thereafter, my lord, an application for anticipatory bail was filed by the petitioner herein for grant of pre-arrest bail. Interim bail was granted, my lord, on 27th of March. However, after perusal of the IO's report and on the request of the IO for that he requires the custody of the accused, anticipatory bail was, my lord, not made absolute, and on the same date he was arrested by the concerned police. Lordship, thereafter a bail application was also moved on 6th of March and 6th of April, and the same was rejected, my lord, on the ground that investigation is still in progress. However, my lord, thereafter another 2 weeks have passed. He has already given his statement. Seizures have been made. At this stage, my lord, I pray that, my lord, that the version of the petitioner here is that the accused person who was involved, in fact, it was he who was the victim, and because of the tussle, he has been implicated into the matter because of the political rivalry. All that, my lord, will be borne out in the trial. At this stage, my lord, I pray if the CD may be called for and if lordship peruses the CD for the consideration of bail, my lord.
Charge sheet has not been filed.
Charge sheet has not been filed, my lord.
Matter is under investigation.
We produce CD.
Hello.
Heard Mr. Lawyer Counsel for the petitioner, who has submitted that this is an application under section 439 CRPC with a prayer for grant of bail to the accused person Shri Sallang H. Barak, who was arrested in connection with Empathy PS case number 27-3 of 2024 under section 435 oblique 506 oblique 307 oblique 34 IPC. The learned counsel for the petitioner, who is the cousin brother of the said accused person in question, has submitted that the accused person was arrested on
3rd April 2024, paragraph 2.
3rd April 2024 and is still in custody. However, before proceeding with the hearing on the merits of this matter, the Lawyer Counsel has submitted that his diary may be called for. His diary may be called. Mr. Kekhal and PP has also agreed that the CD is required to enable this court to produce the same and to pass necessary orders. Accordingly, the prosecution is directed to file a copy of the CD with the latest status report on the next date fix.
The other two anticipatory bail is fixed on 1st May.
Arising out of the same case.
Same. So if this matter can be fixed same day.
This is the one first.
First May.
Deeply obliged, Lord.
Item number 2.
May it please your Lordship. Lordship, I pray this matter may come at the end of the board, your Lordship, as the learned DSGI is engaged in court room number 2, your Lordship.
End of the board.
Oblige, your Lordship.
Daily list, item number 1.
My Lord, I have informed the General Counsel for the respondent. Lordship may give me a week's time to take up this matter.
What is required, Mr.
It's relating to the, my Lord, the
Inquiry.
in relation with the complaint filed against the Langrinchi.
What are you required to do? You're required to receive instructions or?
Lordship, it is fixed for the admission hearing. Today only I pray for a week time to argue the case. I've informed the learned seniors and my colleague.
No objection. Learned counsel for the learned senior counsel appearing for the petition has sought for accommodation in this matter on grounds of personal difficulty. Prayer not being objected to by the respondents, it seems allowed. This is matter up to 1 week.
Come in the regular hearing list. Because maintainability issue has already been decided.
Of course, maintainability has been decided.
When it may be posted for hearing?
The regular hearing board.
This is matter for hearing.
For hearing.
Much obliged.
Item number 2.
My Lord, this matter, the order passed by this council, my Lord, I have annexed one of the impugn order. However, my Lord, I have received the copies from the district council that the similar order was passed by the district council in connection with the other villages.
7 orders have been passed.
7 orders, but the contents and the grounds are same. Date of complaint was the same, only the name of the villages. So what I prayed for, with Lordship permission, allow me to bring on the court by way of filing additional affidavits.
Well, I have some objection to that. I fear for the respondents. These are independent orders, so they would have to be challenged in independent proceedings. As a matter of fact, I was making a prayer before your Lordships. In so far as the other respondents, the other villages are concerned, we would like to file an application seeking striking off because we have nothing to do with the substance of this particular writ petition pending before your Lordships. It's a separate issue, fellows, if they want to challenge all these orders separately by way of individual writ petitions. The substance may be the same, but the parties to the proceedings are different. Well, they're separate individual orders now. And all of that has not been challenged in this. Even if my learned friend brings it by way of a supplementary affidavit, there would not be any substantial challenge to these orders.
Well, that would be quite technical. Complaints are the same. Well, proceedings were passed through together, hearing was done together, and impugn order was passed on the same day. Only, my Lord.
The impugn order is a composite order.
The substance is the same, my Lord.
Substance are the same.
Is the same. Only the name of the villages.
Only name of the villages, my Lord. And when we filed the writ petition, my Lord, we have to give the impression that only single order was passed. Therefore, we annexed that one only. Now, subsequently, learned senior and the other point out that subsequent other different order was passed. So we obtained the paper and we have seen that exactly different orders are there, but the substance contents are same. Only the name is different. So, my Lord.
But are there have you made any specific amendments as regard the?
Yes. All of them are a party in the writ.
They are just parties, there are no permits. If my friend wants to file a supplementary affidavit, let him file. Well, I'll challenge him.
It is. And my friend said that he wants to file an application for striking out. That is his.
Let us file our respective applications and Lordships let them decide.
And one more, Lordship, with permission. Lordship, in the last occasion, Lordship passed an order that the alienation of land should not be taken place during the pendency of the writ petition. So the private respondents, they are taking some steps to alienate the land. Now, after Lordship passed the order, the next day, what happened? The respondent number 6 has gone along with the youths and threatened one of the villager, surrounded him, that if we are going to win the case, we will not allow you to stay in the village. If the writ petitioner win the case, that also will take action against you. Now, he along with the minor were frightened. They filed a FIR also. Well, it is pending. So, on to this aspect, my Lord, I will allow me to bring on record. But this is a serious matter.
Yes,
The
it
criminal
is,
angle is
but
different,
you see, but
but
it
the
in-
conduct
but-
of the other side.
See, but it involves a separate proceedings.
That is true. That is
There will
true.
be
But
claims
the
and
conduct of the
counterclaims to
parties,
this
I want to
extent.
bring on record. I'm not insisting the Lordship may take action in the criminal angle, but the conduct of the parties is important. Parties are in the writ court, so conduct of the parties are very essential while seeking justice.
If there is to be imputation, then it will be done so.
Yes, yes.
It's Senior Counsel appearing for the petitioner has submitted that it has come to the knowledge of the petitioner that the respondent KHADC has issued separate notification or order?
Seven separate orders.
Separate orders.
7 separate orders, which orders are required to be brought on record as far as this matter is concerned. In this connection, the Learned Counsel has submitted that he may be allowed, the Learned Senior Counsel has submitted that he may be allowed to file such notification or to bring on record such notification by way of an additional affidavit. Pray allowed. The respondent in the meantime, on an advance copy being issued upon them, may file their response if so advised.
Those may kindly record, do you want to file an application seeking striking off of?
That is up to you. You file. On previous, this is matter of 2 weeks.
Okay.
Item number 3.
On the last occasion, my lord, I had concluded my arguments subject to what they say. So, and today it's also fixed for filing of written arguments. We have prepared our...
What is required now?
As per the last order, Mr. Bhattacharya has to advance his arguments in CRP number 21. I'm appearing in CRP number 28, my lord.
Okay.
I have advanced my submissions. I have concluded my arguments. I'm only to file the written submissions after I receive a copy of these.
And if you recollect, your lordship, Mr. Bhattacharya, on behalf of the state, Director of Sports, he had made a submission that the records would be necessary. Now the records had already been called for since 2016. The records are already here.
Okay.
In respect of the...
So now what remains?
So what remains is we have to file our written submissions if they have nothing more to add. Because both the sides we have concluded.
But who's representing the state?
My lord, in CRP number 21, Mr. Bhattacharya is representing the state. And as per the last order, my lord, he had prayed to allow him time to advance his argument on the next date, that is today.
Okay.
Or he's in court number 4. We can take it up after some time.
End of report.
Well, my presence will not be necessary. Because 28, I have already concluded my submission.
No, but does he need to respond to your argument?
No, I don't think so. Because in this case, he is appearing for the state also.
I am appearing for the state in CRP number 28. My case is on a different footing also.
Yes. Have you filed your written argument?
Not yet. I will be filing my provided I have a copy of the written submissions by Learned Senior is going to file. Because I'll have to...
They are filing the petition and now they want us to file a written argument first. What sort of submissions is this?
My lord, the matter as it stands today, my lord, is on the issue of maintainability, my lord. The issue of maintainability is raised by my Learned Senior. So, my lord, obviously my Learned Senior has some submissions to advance and is filing his written submissions. So once I have the copy of that, I will file it, my lord.
Must have been given to you.
My lord, a copy of the written
In fact, we
argument is
don't
not
need
been
written submissions, my lord. It's just the decisions.
Whatever.
That is all.
Then I'll file it on the next day.
There's a brief written synopsis of your argument and the decision you're relying upon. Put it down in writing and then...
No, because, my lord, in his case, all the orders they have challenged are appealable. All. The 7 orders that they have sought to challenge before this court, all those orders have either been challenged prior to filing of this revision petition, and the last order passed by the trial court also is appealable. Vidyasagar case is very clear. That is the only ground.
I have earlier also I filed my written submission. I'll file on the next date. On the next date, I'll file my written submission.
2016 matter, we cannot just delay on.
Every time it's next date, next date.
Well, since 2 matters are tagged together, and Mr. Bhattacharya is here to advance his arguments in item number CRP number 26.
That
we will take at the end.
That is okay. That is okay. As far as his argument is concerned, that is okay. But as far as you are concerned, since you have already completed your argument.
So might not, I may
So
kindly
on the
be
next date,
accommodated for the day. On the next date, I will positively file it.
Fine.
Before that.
So as far as the
other one,
the other one is concerned, we'll take it.
Alright.
Item number 4.
May I please, Your Lordship? This matter, my Lord, may kindly take end of the board, my Lord. Conducting counsel, Mr. S. Sheikh, is on his legs in other court, my Lord. End of the board, my Lord.
Item number 6.
Yes, so Mr. Barwa, you have to start your.
Actually, they filed this affidavit. Let them reply. Let them argue. They start.
What affidavit?
They filed an affidavit bringing on record certain documents last time. So you received the copy. So let them start the state because state has filed.
Have you filed rejoinders with the?
No, I'm not filed the rejoinders. No, I'm not filed anything. Let them start.
So the matter, you see, the matter rests there as far as the pleadings are concerned.
The pleading is concerned.
Now you start with the argument of the case, on the merits of the case.
Lordship, the case of the petitioners out here is that the petitioner has been allotted with the plot of land of the industrial area of the Jaintia Hills, for setting up a sawmill. Has been set up. Okay, it has been long time back because earlier it was in the Mimintadu. After the direction of the Supreme Court, that has been transferred to the industrial area. It has been allotted. Permission has been granted, the mill was created, and this is going smoothly. Thereafter, high tension power line has come on top of that unit, okay, causing the great danger, okay, which is already the part and parcel of the petition. It is as annexures, okay, where the state government has categorically said that the power line which is gone above the unit without obtaining any objection, NOC, they have erected, so this is illegal. Removing, not removing, who will take the expenditure, everything has been, it has been the part of the, it is to be borne by the person, the department which is elected, the MECL. So thereafter, we filed a lot of correspondence, no response has come. So when there's no responses come, even the government also declared that the entire erection of the power high tension line over the property of the unit, it is illegal, okay. So thereafter, we approached the MECL has communicated to us that you have to give the expenditures, whereas they have illegally come, which is declared by the government. But thereafter, they said, no, you have to bond the expenditures. So since we communicated, nothing has come up, so we are coming before this court. Okay. So thereafter, on Lordship, on the 28th of the issue is because it is partly heard. The issue is what mainly is heard that who started the things, whether the power line has come before or the unit has come before. So in this regard, this Honorable Court has passed an order on 20th July 2022 to bring on record certain documents which proves that who started the first, okay. Whereas we have filed an affidavit in this regard, mentioning that since when we have the inception of the things, how the unit has been transferred, Prior to it was in Mimintudu, it has been transferred. But as far as the 4 and 5, the MEC is concerned, they have not bring anything on record to show that when it is started. Only in their affidavit they said that we have communicated one letter to the state, okay, but state has nothing to show on the record that they have given the permission to them. But as far as this letter is concerned, Your Lordship, my main petition, page number 23. Annexure A8, page number 23.
Page number?
Page number 23 of the
23,
main petition, Annexure A8.
Oh, this is an amended petition.
Yeah, in the main petition, Your Lordship. This amended petition, Your Lordship, in the amended petition.
Yes.
I just read the content of the motion.
Yes.
That has been written by the Director of Commerce and Industry to the Executive Engineer, Joy Distribution Division, Jaintia Hills. Subject is shifting of 33 kV/11 kV line at Industrial Estate, Kilchichi. Sir, kindly refer to the report of the joint survey for the shifting of the 33 and kV D-circuit line at Industrial Estate, Kilchichi, conducted on 10/3/2016, jointly by Sri so-and-so, 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 DCIC Juai and Sri so-and-so Assistant Director of Cottage Industry Juai, wherein inter alia it had termed the construction of the building of the petitioner MS Bislina Warpasa, Kam Sawmill, Sawakam Vinaya Mill within the industrial estate as illegal and also recommended for shifting the line. So here the government is writing to the respondent 4 and 5, okay, whereas the inspection has been done by so and so person, and they demanded this industrial things as illegal. The construction of that unit is illegal and should be shifted. On perusal of the report, this is very important, an available document, it is found that the MECL has not obtained the NOC permission from the department for the construction of the 33 kV. That is in 2017, November. 29 November 2017.
Yes.
kV line passing through the Kritirchi industrial area, because the line is not just passing over the things, it is passing through over the entire industrial areas. The joint, now it is very important, number 2, the joint inspection team is not competent authority to declare any building or structure as a legal or illegal. Now this team which is recommended, they should be shifted and should be declared as illegal. They have no authority to declare such things. So in view of the above facts, the report submitted by the team is therefore not acceptable. The MECL has trespassed. This is very important, Lordship.
Yes.
It's categorically saying trespass into the land should shift the HT line to a safe place and providing right way and expenses required therefore shifting of the line is the sole responsibility of the MECL being the service provider. It may also be noted that the service provider will be answerable for any untoward incident. This is now, what is the unit? Unit's function is what? As a sawmill, Your Lordship. You have to understand we have to understand the veracity of the things. If anything, a slightly mishap, not just the unit of the petitioner, and this other sawmills also there, it will be affected vastly. So untoward incident arising from the HT lines. So this contention of the state government, which is communicated to the respondent 4 and 5, in other letters also they have communicated the same thing, saying that you posing your entire process is illegal and you posing your stranger. And as far as the shifting of the line from there is concerned, okay, they are saying that we should take the bond the things, entire expenditures. The department is saying that no. Even they ask from the department also. Department is saying that no. It is your line, you erected, what are the expenses required, that is should be shifted. And due to which, because my entire unit is running on the workers, there are a lot of laborers are there. So all they feeling fair that if anything mishap happens, so they might cause a great danger to their life also. So nobody want to work there. The unit is totally shut down right from 2017. There's no activities going on because no workers is there. Nobody wants to leave because since the workers they started working, they have to stay there. So staying also because it's coming on you can see from it's just a distance of a few things, inches between the line and the unit. So thereafter we filed the things, correspondence, they have rejected all the things, so we come before this court. So in this regard, the state has filed in their affidavit. This is important. That is, kindly, Lordship, in the affidavit of the respondent number 2 and 3.
Just a moment. Is the affidavit dated 10/7?
10. No, that is 9 July 2019.
Yeah.
Affidavit of respondent 2 and 3.
9.
The last page, Your Honor, Annexure 2.
Just
Page number 12, Your Honor.
Yes.
Yes, page 2, my read. This letter is written on the 8th July 2019. That is by the same state respondent, which is the part and parcel of the Annexure 8 of the main petition, in the petition, writ petition. The Actor of Commerce Industries to the Executive Engineer, Joy Division, West Jaintia Hills. Subject, shifting of 33 kV 11 kV line at industrial estates. Now they are taking two stands for the same point, same issue. On examination of the earlier communication issued by letter dated so and so 29/11/2017, that is the Annexure A8 of the main petition, and taking into that the then MECV has sought cooperation of all concerned authorities, including this department, prior to the construction of KV line, which passed through the Clayton Estate, Jaintia Hills. Construction of the 33 kV line is meant for, this should be uninterrupted supply, but supply of power and for the larger interest of the public.
Meant for interrupted supply?
And for larger interest of the public. So letter dated, which is the part and parcel of the next A8,
Yes.
29/11/2007 is hereby recalled and cancelled. That is also during the course of pendency of this petition. 2017 they are saying that they are wrong. Now in 2019, after filing this petition, that is well thought. In 2019, this matter is filed on 2018. On 2019, they are coming and saying that we withdraw that earlier letter. Okay, they have sought the communication. Now what communication? So that means in these cases, whether you in that point of time, initially in 2017, they are correct, or in this point they are correct. For the same letters at one point of time saying that is totally wrong. Nothing is sought, no NOC, nothing. You just gone by yourself. Now in 2019, after filing this petition, they have come up with the point that no, they have sought the other things. So what things help the corporation they have sought? I'll come to the things. Affidavit of the respondent 4 and 5. Yes, this is 4 and 5, Your Lordship. Affidavit in opposition of the 4 and 5. Page 7.
Yes. Yes, affidavit dated
That is affidavit dated
13/12.
13th December 2018.
Yes.
Yes, that is Annexure 1. The letter date is 22nd May 2007. It is written to the manager DIC Kletirchi, the principal IIT Kletirchi, and headman of so and so villages. Number 5 villages.
Yes.
Subject: construction of 33 kV line from Kletirchi village to the Northing village. With reference to the subject cited above, I am pleased to inform you that the Meghalaya State Electricity Board will soon start construction of the 33 kV line from the Kletirchi to Northing village. The aim of this project is to improve and maintain the stable power supply to your areas. In this connection, the board needs your full support and cooperation so that the construction works, once taken up, be not be interrupted or disturbed for the smooth and timely completion of the project. So your sincere support and cooperation is undoubtedly help us to happen the things. So now this is the only letter that respondent number 4 and 5, which is they communicated to the state that seeking the permission. Whether the permission has come or not, nothing on the record, which is filed by the state respondent to show that yes, we have given the thing. Okay. So now if you take into consideration this letter, they've communicated. Okay. And in pursuant to that annexure A8, which is part of the main petition, they are saying that they have not obtained anything, any permission. They have written letter. This is on record. But whether permission is granted to them, it is still date, it is not been on record. So thereafter, I'll come to the now my additional affidavit of the petitioner for inception. Before that, I like to pray before this court. Lordship, can I go to the order dated of this honorable court, 20th July 2022.
Yes.
Your Lordship, in the earlier stage when the argument was started, so before this honorable court was the issue was that who started the first inception of whether the inception of the unit has come up or the power line has come up. So that is the main issue. So in this regard, the honorable court has passed this instant order 123. I'll just read out the things, Your Lordship. The learned counsel for the respondent 4 and 5 has submitted that the information as regard exact date when the said high tension line was erected over the land of the petitioner may be allowed to be filed by way of an additional affidavit.
Yes.
So that is not come up.
You have not filed?
No, they have not filed. And whereas, I go to the second line, Lordship.
Yes.
The petitioner has also submitted that additional affidavit may be allowed to be filed to bring on record certain document as regard to the inception of this his unit over the land in question.
Yes.
So there's a two set of things in this order. 4 and 5 said that we will bring on record when the line erected, and our condition maybe allowed us to file in a affidavit to bring on the things when we started the things. I'll come now. This is my additional affidavit dated, Your Lordship, 23rd August 2022. That is order was 20th July. I filed on 23rd August 2022.
Yes, sir.
Para 3, Your Lordship.
Yes, sir. Para 3.
Para 3. I'll start from para 3, Your Lordship.
Yes.
Yes. Your Lordship, sorry. I start from the para 2. That the petitioner in it was initially functioning from the area meaning to do that Jaintia Hills district, now West Jaintia Hills district, Meghalaya, from the year 1994. That means this unit was functioning right from the 1994. Now para 3, that thereafter on 9th September 1999, the respondent 2 issued a letter to the petitioner for proposal for allotment of the land. That means my land was allotted in when 1999 of the land.
You're reading
This additional affidavit to bring on a certain document. No?
Yes.
Yes, sir. The para 3.
That is statement made in so and so.
No, that is. No, this additional affidavit to bring on record certain document to ascertain the inception. For this is this.
No, the additional affidavit by you to bring on record type copy of an exchange.
No, not this, Your Lordship. Another. This is regarding the map.
Yeah.
Another. Certain document is for the inception. Also.
Okay.
I'll just read. Para 2. The petitioner unit was initially functioning from the area Mimintudu, then Jaintia Hills district, now West Jaintia Hills district, Meghalaya, from the year 1994. Para 3. That thereafter on 9/9/1999, respondent number 2 issued a letter to the petitioner for proposal for allotment of the land at the industrial state Kretrichi, West Jaintia Hills district, and directed to apply for the provision registration certificate from the respondent number 3, which is the annexure 1 in page 6, Your Lordship, that letter. It is written by the Director of Industry Meghalaya to the petitioner, and some other things also. Units were there, they written there. Because they are shifting on the direction of the Supreme Court. They are shifting the entire unit to the new industrial area. So, para 4, while letter dated 2/11/1999, the respondent number 3 has issued a provisional certificate. So, thereafter they have issued a provisional certificate. He applied the provision. That means once the provisional certificate is issued, that means I am holding that land, whether lease or actual, right from the 1999. So, thereafter, para 5, thereafter the Divisional Forest Office T, Jaintia Hills Division Joy, while letter dated 7/6/2004, issued a letter to the petitioner for shifting of the sawmill, which is in Mimintudu, from the Mimintudu industrial area, in view of the direction of the Honorable Supreme Court. That is Annexure 3, Your Lordship. I'll just read out. Page 8.
Yes.
It is written by the Divisional Forest Officer T. Jaintia Hills to the all the C units, which is petition units also there. Subject: shifting of sawmills cleared by the HPC to notified industrial state. In view of the CFME have clarified independently through his letter dated 2/6/2004, stating that those sawmills cleared by the HPC High Power Committee, that is, may be allowed to shift to industrial state, establish their machineries at the allotted site. You are hereby directed to shift your machinery and equipment pertaining to the sawmill to the plot allotted to you within 15 days of this letter. This issue as per the direction of the Supreme Court in their order dated 15/1/1998. There's some issue as the petition was filed in the Supreme Court. The Supreme Court given direction that that this unit should be shifted to the new industrial areas. So on the basis of this letter, they shifted that. That means my entire application, my process to the shifting from I was running that my unit is a Mimintudu, previous area, then area. So it was in 1994. In 1999, I've been directed to shift my industries. That means my communication with the state is going right from the 1999. Okay, I was allotted, the moment I was allotted the land, that means I am the part and parcel of the one of the things for the particular time. Okay, if anybody coming, even if I don't construct also, if anybody is coming on top of my land, so they must take the consent. They must take the consent from the state and the person who is in possession of the land. But in this case, they have not taken anything which is already been on record, that they have not sought any NOCs or anything. They have just come up with the things. So now the question of the inception has come right from 1999, Your Lordship. So now the issue has come that they have come and said, "No, we started first, I started first." As far as the inception of the unit is concerned, it is on record. I've already filed the things. But as far the inception of their power is concerned, they have not nothing brought in record. So there's just only one letter which is communicated in way back in 2007. In regard to that, there's no communication, no permission was granted. So my humble submission is that whatever the damages that I suffered during these years, okay, without running the things, because I have a lot of bank loans, a lot of debts are there. My entire unit has come down. So I have the liabilities in the market. Okay, my business come down, my reputation has come down. And the mental agony that I have suffered during this period, I should be compensated for that. And the action should be given to shift that line because it's causing great danger to my unit. So this is only my submission that I should be compensated and the line should be shifted immediately.
So that means since the high tension wire, came into existence, you have not been running the unit.
No, it's not possible because I'm not getting the work also. Because if Your Lordship, I'll just bring it to the things, the petition, my petition. There's some other communications also there, Your Lordship. This annexure is already proof. This causing the danger. Even annexure A4 in my amended petition, page 18. I'll just read out, Your Lordship. Page 18, annexure A4 in the amended petition.
Yes.
Yes. This is again written. It is written on 2016. Prior to that, annexure A8 was written in 2017. That means they have reiterated things. Here in 2016, the same concerned authority is written to the MECL, shifting of 33 kV. 33 kV and 11 kV line distinction with reference to your letter data cited above. That means they have communicated. I am to reiterate that the 33 kV and 11 kV line which passes through the Cleartherchi industrial area in general and industrial unit of MS Bislina, that is a petitioner's unit, Warpasa Sawmill, come veneer, in particular were constructed without obtaining. Here also they are saying the same thing. That means in two communication they are saying that they have not obtained the things. But during the course of pendency of this petition, writ petition, the state government has come up with another argument saying that no, they have communicated or they sought the help. So now we are doing these letters. So that means that they have not informed the court also that there should be, if you are withdrawing the matter, you should have filed in a separate application. This is not way to bring on the record on by way of affidavit. You should file an application. There should be an hearing. Then if the court finds that yes, that action is legal, then it can be withdrawn. But here nothing. They just bring on record through way of affidavit. In the additional in their affidavit, main affidavit, they brought the things. Here in two instances, they are saying that they have not obtained the permission. Now all of a sudden they are coming saying that no, we are just withdrawing this letter. Now
somehow the petitioner is trying to make out a case that the MECL and the state are in conflict, which is not the fact matter. Ultimately, it is the state and it is another form of
just a minute. Actually, in fact, the state government is totally running in the ambiguity. Okay, they are not in a clear. They are like whether we are wrong or they are wrong. In one point of time saying that no, state what do you call 4 and 5 is the construction is illegal. Now they are bringing my things additional affidavit that they file. They are saying that after a gap of 3 to 4 years, they are coming up and saying that my construction is illegal. Now first you decide whose construction is illegal, whether it's theirs. No, that is not the no. Yeah,
yes, understood.
So my learned senior's argument is that no, this is the matter of facts and things. No, we are
just have you finished? Just you'll get your chance.
What I'm saying is that this is not on a record question, not a disputed. Because in one point of time they are saying that they are illegal, in one point now they are coming with the things after filing this petition. They are saying that we are in the wrong thing. That means you are confusing the entire matters out. The issue is not as a ownerships here. I'm not fighting for the title out here. I'm just fighting is that somebody has entered to my area, my land, illegal constructed, obstructed to my business. So this code is This court has jurisdiction to decide the thing. I'm not fighting for my rights or what do you call this, my titleships. Had it been the titleship, then definitely. If the land is allotted to them also, to us also, so that is a question of titleship. Here the allotment to land is given to the petitioner. And they're saying that we have the permission to erect the line. So now the permission is to erect the line is on the record or not. So that is only my things. The rest is my prayers will remain same. So let them things, I'll respond to that.
Yes.
May it please, Your Lordship. Lordship, I will start from the beginning, my lord. Kindly see what is the prayer in the writ petition.
You will be appearing for?
For my lord, MECL as well as state reply is common, my lord. But I will be leading everybody, my lord, in this matter because the issue is common in all the cases, my lord. Now, what is the case which has been set up by the petitioner before your lordship? That we have to get the idea of and to follow what is the case which has been set up by the petitioner before your lordship. Now, what he says, my lord, kindly see in paragraph 1. Is a bona fide citizen of India and resident of so and so. Paragraph 1, my lord, at page 2, my lord. Resident of so and also Bilisna War Pasa Sawmill Veneer is entitled to rights and privileges guaranteed under the Constitution, my lord. That is, he says that he is proprietor and he has certain rights which has to be. Now he is aggrieved, my lord. Paragraph 2, my lord. He is aggrieved by the action of respondent number 4 by which the land of the petitioner is being occupied by way of illegal encroachment without the sanction of law. Stand of the government, especially respondent number 4, is against the right of the petitioner. Therefore, respondent cannot claim land and forcibly encroach the land of private party. By this action, respondent is also infringing the constitutional right. So, respondent number 4, may not kindly note is the executive engineer, Jovite Distributions. So, what is the case that respondent number 4 has forcibly occupied the land of petitioner? That is the case of petitioner, my lord. That is now. Kindly see, petitioner here in state that is the leaseholder land in the Clariot Industrial Estate area in West Jantia Hill, Meghalaya, which is sought to be forcibly acquired by contravention of the fundamental right. So what he is claiming, my lord, that he is having leasehold right of Clariot Industrial Estate, my lord.
Clariot or Clittersi?
Oh, sorry, Clittersi Industrial. My pronunciation is a little bit rusty. But this is the industrial estate, my lord. In this industrial estate, he is saying that he is having leasehold right, my lord. Now, I put a question to myself, my lord. Has he produced any document showing his leasehold right, my lord? Because he is saying that I am having leasehold right and that leasehold right has been disturbed by the respondent number 4. And therefore, I am entitled to compensation. That is what he is trying to say, my lord. Now, kindly see that, and what he says further, my lord, in the paragraph 3, and the state of the Meghalaya is sought forcibly acquired by contravention of fundamental right. So, what is his case, my lord? That this leasehold right has been occupied by state without giving him compensation under the Land Compensation Act.
No, that is amended.
That is paragraph 3. Paragraph 3 I am reading. Paragraph 3 I am reading. I am reading your writ petition. I am not reading anything else.
No, I think he is reading that previous writ petition.
This is the amended.
Amended, yeah.
No, this is the amended.
The page number, which para?
Paragraph 3.
Paragraph 3, your lordship. Paragraph 3, your lordship is getting, because I am having this writ petition only with me.
No, this he is reading from the amended writ petition.
But paragraph is not saying that things. Anything written?
No, I will read it 3 slowly again. The petitioner here in state that is the leaseholder land in Clittersi Industrial Estate area in West Jantia Hill district, Meghalaya, which is sought to be forcibly acquired by contravention to the fundamental right of petitioner and also in contravention of a statutory mandate
no, that is
of the right. This is not the correct writ petition.
My lord, this is my senior what he's reading. That is the only copy which is with me,
we
my
have
lord.
already served the copy.
My lord, they must have sub only to the state respondents, my lord, to Mrs.
No, I've
Sengupta.
And your lordship is having this copy only or some other copy? Your lordship is having this is the only.
I have the amended writ petition with me.
And paragraph is matching, my lord. My whatever I am reading paragraph.
It is not entirely matching. Though some part of it is matching, and some is.
Sorry, my lord. I'm sorry.
My lord, this is the only copy which I have it with me.
No, we have given the copy to the ABCL because I supposed to give it to the. He said no. It is instructed that it should be given to the department. I submit to the department. I have
No,
the.
I have
I have the
I
copy.
have not been informed about any copy being received at the office.
Then you have not been properly instructed.
My lord, my friend could have given because I have already entered appearance in this matter for
No,
more than a year. So
No.
this amended petition has subsequently come on 22, my lord. So I was already counsel in this matter at that time. You could have served to me directly.
I came to the friend.
No issue, my lord. My lord, what I can do is, my lord, we ultimately matter has to be argued on merit. My friend can give me the amended, and your lordship may have it on Monday. I will argue the matter on Monday.
Okay, let's see. I'll just copy it.
I'll argue the matter on Monday, my lord. But whatever amendment, all documents you can give because that will help us in assisting the court. That will help us in assisting the court.
Yes,
I'll continue my argument on Monday, my lord.
With all the
With
annexes,
everything.
In fact,
complete.
I just humble things. I approached to my learned friend. Okay, she said that the department has instructed down that anything which is any copy served, it should be served on the department. Then the things. I went personally to the thing, to the department. I submitted here. So thereafter, they have not received that is anyway. I'll just think because the matter should be.
Please, sir, I'm sorry for the difficulty or the trouble caused to you. Give a copy to me, my colleague now. I will argue the matter on Monday.
I'll serve the copy.
Mr. Agarwal and counsel for the petitioner. The hearing will continue on the next date fix. Yeah. This is matter on 29.
On Monday.
Obliged, my lord.
That's Monday.
Obliged. Grateful, my lord.
Item number 9.
May I please, your lordship? My lord, the issue here is no more res integra. The issue has been decided in the catena of judgments, my lord. The issue involved here is the employees here are claiming for an equal pay for the equal works, my lord. And my lord, here the first of all they have raised is this is filed by the union, my lord. Union on behalf of all its members. Now, therefore, all the members are having the same interest, my lord. So, therefore, the application filed by the union, which is a registered union, is maintainable because this is one of the first challenge that the respondents has put up, my lord. Now, if my lord will see, before I take my lord to the judgment, that would suffice because this judgment covers my case fairly and squarely. So, therefore, my lord, I will take my lord to
go to the facts first.
Yes, my lord. Paragraph 5, my lord. Paragraph 5 of my petition.
To MECL.
MECL, my lord. Yes.
Mr. Pandey is on the board, my lord. He'll be arguing.
Yes, my lord. I am there for MEC.
Yes. So, my lord, paragraph 5.
Just a moment. Paragraph 5.
Yes, my lord. And before this, my lord, what is the status?
Yes.
What is the status and the designation of my members, my lord? The status and designation of members are, my lord, they are the long-standing casual workers, my lord, doing a regular job, my lord. Now, our agreement itself says that there will be an automatic renewal, my lord, till the day we attend superannuations, my lord. So this automatic renewal is there, my lord. It's not that need by need basis.
So there is no, question of, regularization or,
The question, my lord, that question is not under challenge, my lord. That question, but for the purpose of this petition, that question is not under challenge, my lord. So now, my lord, our member, as I said, is a long-standing casual workers doing regular job. Now, paragraph 5, my lord, may I draw my lord's attention to paragraph 5. It says the members of the petitioner are appointed in the sanctioned posts, which posts are also available in regular cadre. The nature and responsibility of the work are same for both. A comparison of the posts between the two and the nature and the responsibility of work is illustrated herein below in the table format for brevity. So, my lord, the first box is the name of the post held by the members of the union, like Mali. Now, the next is the name of the post in the regular cadre, Mali. So the nature of work is the same. So this is the illustrative diagram which I try to project, my lord, where to say that we are doing this, my members are doing the same job. If it's a Mali, there is also a sanction, there is a regular post for Mali, and we are doing the job of the Mali. And if it's a sweeper, my members are also a sweeper, there is a regular post of the sweeper, we both are doing the same kind of job. This is the illustration. Now, my lord, if my lord, I draw my lord's attention to paragraph 6, my lord. Now this comes a disparity in terms of pay, my lord.
Yes.
Paragraph 6, my lord. That the petitioner states that they are appointed against posts available in regular cadre, performing similar duties and responsibility as being discharged by regular employees holding same corresponding post. It is humbly submitted, even though they are performing same nature of job, they have been discriminated when it comes to paying their wages. A comparison of the pay as per the Meghalaya Energy Corporation Limited revised of pay regulation 2020 between the members of the union and to the regular employees performing same nature of works are given herein below. Now, my lord, the first is the designation. We all have the same existing pay scales and revised pay scale of the regular employees are the third column. And what we are drawing, my lord, is for the cleaner, Mali, sweeper, Khalasi, we are drawing 10,290 plus increment 5% for a year, 10% for 10 years, 15% for 15 years. The maximum 15%. Now suppose 10,290, 15%, my lord, how much it will come to? Some 1,000 rupees, my lord. So, my lord, this is the discrepancies here, my lord. Therefore, we say that now, my lord, extracting the same nature of job and then paying us less, that is not less than a modern slavery, my lord. This is a discrimination, my lord. It's an exploitation in a proper word to say, my lord. So now, my lord, this if I be able to convince my lord that nature of works, we hold the same post. When it comes to payment, my lord, we have, in spite of doing the same nature of job, taking the same risk, my lord, we have been paid in this manner, not even the minimum pay scale. Now the judgment, my lord, which I would like to refer, my lord, is the 2017 1 SEC 148, my lord, State of Punjab and others versus Jagdish Singh and others, my lord. And this covers the entire field, my lord. And para 42 onwards, my lord, if I permitted to read, para 42 onwards, my lord.
2017?
2017 1 SEC 148, my lord. I think we have given the book, no? Yes. We have submitted the citations, yes. My lord. Yes, my lord, yes. So, my lord, may I draw my lord's attention from paragraph 42 onwards, my lord? That is page 205, my lord.
Yes.
Page 205, my lord. Now, this has been discussed after discussion of so many judgments, my lord, which holds in favor of and which holds against me. After discussion of so many judgments, my lord, not less than 12, 13, even more than that, my lord, then the Honorable Supreme Court comes to this conclusion, my lord, which I may be permitted to read, my lord, here. The consideration. All the judgments noticed in paras 7 to 24 herein above pertain to employees engaged on regular basis who were claiming higher wages under the principle of equal pay for equal work. The claim raised by such employees was promised on the ground that the duties and responsibilities rendered by them were against the same post for which a higher pay scale was being allowed in other government departments. Or alternatively, their duties and responsibilities were the same as of other posts with different designation, but they were placed in the lower scale, having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay for equal work was invoked and considered. It would be just and appropriate to delineate and the parameters laid down by this court. In recording the said parameters, we have also adverted to some other judgments pertaining to temporary employees also dealt with in the instant judgment, wherein also this court had the occasion to express a legal position with reference to the principle of equal pay for equal work. Our consideration has led us to the following deductions. The onus of proof of parity in the duties and responsibilities of the subject post with reference post under the principle of equal pay for equal work lies on the person who claims it. He also approaches the court has to establish that the subject post occupied by him requires him to discharge equal work of equal value as the reference post, Orissa so and so so in case. 42.2, my lord. The mere fact that the subject post occupied by the claimant is in different department vis-a-vis the reference post does not have any bearing on the determination of a claim under the principle of equal pay for equal work. Persons discharging identical duties cannot be treated differently in the matter of their pay, merely because they belong to different departments of the government. 42.3, my lord. The principle of equal pay for equal work applies in cases of unequal scales of pay based on no classification or rational classification. For equal pay, the employees concerned with whom equation is sought should be performing work which, besides being functionally equal, should be of the same quality and sensitivity. So and so cases. The 42 persons holding same rank designation but having similar powers, duties and responsibilities can be placed in the different scales of pay and cannot claim the benefit of the principle of equal pay for equal work. So, therefore, the principle would not be automatically invoked merely because the subject and reference posts have the same nomenclature. Now, 42.5, next page, my lord. In determining equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that the duties of the two posts should be of equal sensitivity and also qualitatively similar. Differential of pay scales for posts with different in degrees of responsibility, reliability and confidentiality would fall within the realm of valid classification, and therefore a pay differentiation would be legitimate and permissible. Now, my lord, and also the level of responsibility. Then 42.6, my lord. For placement in a regular pay scale, the claimant has to be a regular appointee. The claimant should have been selected on the basis of a regular process of recruitment. An employee appointed on a temporary basis cannot claim to be placed on the regular pay scale. See Orissa, this is a judgment. But this will be differentiated later, my lord. I'm reading out all this. That's why this will be differentiated towards the end, my lord. Persons performing the same or similar function, duties and responsibilities can also be placed in different pay scales, such as selection grade in the same post, but this difference must emerge out of a legitimate foundation such as merit or seniority or some other relevant criteria. So if the qualifications for recruitment to the post to the subject post vis-a-vis the reference posts are different, it may be difficult to conclude that the duties and responsibility of the posts are quantitatively similar or comparatively. In such a case, the principle of equal pay for equal work cannot be invoked. The reference post with parity is claimed under the principle of equal pay for equal work has to be at the same hierarchy in the service as the subject post. Pay scales of posts may be different if the hierarchy of the post is in question and the channels of promotion are different. Even if the duties and responsibilities are same, parity would not be permissible as against superior posts such as the promotional post. Now, my lord, my lord will skip some of this one, and because just to save time, then 43, my lord, paragraph 43.
Yes.
Because I was just reading out the first conclusion is that both for me and against me the judgments. Now, my lord, the 43. We shall now venture to summarize the conclusions recorded by this court. With reference to claim of pay parity raised by temporary employees, differently designated as work charge, daily wage, casual and ad hoc, contractual and the like, in the following two paragraphs. We shall first outline the conclusion drawn in the cases where a claim for parity raised at the hands of the temporary employees concerned was accepted by this court by applying the principle of equal pay for equal work with reference to regular employees. In Dhirendra Chamuli case, this court examined a claim for parity raised by temporary employees for wages equal to those being disbursed to regular employees. The prayer was accepted. The action of not paying the same wages despite the work being the same was considered as violative of Article 14 of the Constitution. It was held that the action amounted to exploitation in a welfare state committed to a socialist pattern of society. In Surinder Singh case, this court held that the right of equal wages claimed by temporary employees emerged inter alia from Article 39 of the Constitution. The principle of equal pay for equal work was again applied when the subject employee had been appointed on temporary basis and the reference employee was born on the permanent establishment. The temporary employee was held entitled to wages drawn by an employee on the regular establishment. In this judgment, this court also took note of the fact that the above proposition was affirmed by a constitution bench of this court in D.S. Nakara case. In Bhagwan Das case, this court recorded that in a claim for equal wages, the duration for which an employee would remain or had remained engaged would not make any difference. So also the manner of selection and appointment would make no difference. And therefore, whether the selection was made on basis of open competition or was limited to a cluster of villages was considered inconsequential insofar as the applicability of the principle is concerned. And likewise, whether the appointment was for a fixed limited duration, 6 months or 1 year, or for an unlimited duration was also considered inconsequential insofar as the applicability of the principle of equal pay for equal work is concerned. It was held that the claim for equal wages would be sustainable when an employee is required to discharge similar duties and responsibilities as regular employees. The employee concerned possessed the qualification prescribed for the post. In the above case, this court rejected the contention advanced on behalf of the government that the plea of equal wages by the employees in question was not sustainable because the employees concerned were engaged in a temporary scheme and against posts which were sanctioned on a year-to-year basis. In Delhi rated wage, this court held that the principle flowing from Article 38.2 of the Constitution, the government could not deny a temporary employee at least the minimum wages being paid to an employee in the corresponding regular cadre, along with dearness allowances and additional dearness allowances, as well as all the other benefits which were being extended to casual workers. It also held that the classification of workers as unskilled, semi-skilled and skilled doing the same work into different categories for payment of wages at different rates was not tenable. It was also held that such an act of an employer would amount to exploitation, and further that the same would be arbitrary and discriminatory and therefore violative of Articles 14, 16 and 16 of the Constitution. In the state of Punjab versus Davinder Singh, this court held that daily wages were entitled to be placed in the minimum of the pay scale of regular employees working against the post. The above direction was issued after accepting that the employees concerned were doing the same work as regular incumbent holding the same post by applying the principle of equal pay for equal work. Now, my lord, we come to 46.3, my lord. 46.3. That is at page 212, my lord.
Yes.
These are all discussion. Then 46.3. For having noticed, my lord has that.
Yes.
Having noticed the conclusion drawn in the state of Haryana versus Jasmeer Singh, it would be relevant to emphasize that in the cited judgment's notice at paragraph 26 onwards up to paragraph 41, the employees concerned could not have been granted the benefit of principle of equal pay for equal work, inasmuch as where it was granted because temporary employees in the were never selected through a process of open selection by a specialist selection body. We would therefore be obliged to follow the large number of cases where pay parity was granted other than the instant regular judgment, singular judgment, recording a divergent view. So this is the view which was taken singularly. It says that you have not come through a regular process, therefore you are denied. But in the larger judgments, my lord, this is a different view. Therefore, they have differentiated this Jasmeer Singh's case, because this is exactly what the contention of the respondents MECL would be. They would say that no, you don't qualify, you have not come through a regular process of appointment, therefore you are not granted. But this has been differentiated. Now, my lord, for this 54. Now the conclusion part, my lord, 54 onwards I will read, my lord. I will only read only those parts which is. My lord may just note down 54, may go through letter just to cut short. I will go to 56, my lord. This also reiterates the same 54, and I will go to 56, my lord.
Yes.
Now we shall now 56, my lord. We shall now deal with the claim of temporary employees before this court. 57. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized by us in para 42 herein above. The principle of equal pay for equal has also been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, contractual, and like. The legal position relating to temporary employees has been summarized by us in paragraph 44. Herein above, the above legal position, which has been repeatedly declared, is being reiterated by us yet again. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such as an action considers being demeaning strikes at the very foundation of the human dignity. So, my lord, and it came to 58, then 60, my lord, 62, 60, 61, 62, there's a conclusions, my lord. Therefore, my lord, this judgment, my lord, this judgment it holds the field, my lord, when it comes to equal pay for equal work, my lord. Therefore, my lord, here the members of the union, my lord, as I've pointed out at my paragraph 5 and paragraph 6, my lord, have been employed against a sanctioned post which corresponds to a permanent post also, and we are doing the same nature of work. We are taking the same quantity of work, the quality work, and taking the same amount of risk. Yet, my lord, we have been paid it on the wages, which is far less than the minimum pay scale, my lord. So what we are demanding, my lord, as a member of the union, as a union for our member, my lord, our member, is that, my lord, at least all the members should be paid a minimum pay scale, my lord, as minimum pay scale and other benefits which is available to the regular post, my lord. That is all, my lord.
Milord.
Yes.
Milord, this case, as it stands, is as my learned senior colleague submitted, is regarding equal pay for equal work for temporary employees. Now, I will also place reliance upon my lord's para 5 of the writ petition, which is, in my humble submission, important for considering whether the petition itself is maintainable or not. My lords may just have para 5 of the petition, and
yes,
my lords may see that para 5 says that the members of the petitioner are appointed in a sanctioned post, which posts are also available in regular cadre. The nature and responsibility of work are same for both. A comparison of the posts between the two and the nature and responsibility of the work is illustrated herein below in the table format. Now, my lords, what thereafter ensues is a list of so many posts, and it goes on till for a couple of pages, which has been combined into one, and a petition has been filed by the union. Now, Milords is aware that as far as the cases for equal pay and equal work is concerned, it is sine qua non that identity of post is established beyond doubt. My learned friend just read paragraph 42 of Jagjit Singh's case, and paragraph 42.4 categorically says that there is an onus of proof on the petitioner to show beyond doubt that there has to be identity of these posts, the nature of work has to be identical. Only then there can be any conclusion as far as parity is concerned. So today, my lords have been asked to pass a judgment, a mandamus, as far as equating these posts is concerned, and these are innumerable number of posts which has been combined into one, and a petition has been filed. So my submission is that the petition in the present format is not maintainable because it does not put forth specific pleadings in respect
so
of any of the posts.
You mean to say it's lacking in details?
It is lacking in details, and it cannot be prosecuted in this fashion, Milords. In my humble submission, it has to be a single petition in respect of a particular post, and that may be, if at all, can be considered as a petition which will require any consideration. In the present format, the petition itself does not require any consideration. Secondly, Milords, may see in this regard the prayer which is sought in the petition, because it is impossible to pass a direction or an effective order in such a petition. Milords, may just have page 13 of the petition.
Yes.
The petition, Milord, says, the prayer says, issue a notice directing the respondents to show cause as to why a writ of mandamus shall not be issued directing the respondents to pay the members of the petitioner who are appointed as regular, casual, contractual employees to grade 3 and 4 posts with minimum pay scale revised from time to time with permissible allowances such as dearness allowance as were being paid similarly place regular employees with arrears of pay. So a blanket order is being sought for in respect of all posts like linemen, carpenters, malis, and so on and so forth without any determination. So, Milods, that in my humble submission is not permissible. Secondly, this is something which is completely an administrative exercise, the tedious administrative exercise of drawing parallel between two posts. That, Milods, in my humble submission is not permissible in writ proceedings before a writ court, because there are various factors that an administrative body has to take into consideration. It may be the nature of the appointment, the responsibilities attached with the work, the volume of the work, and the amount of qualifications that a person has, the nature of the appointment of that work, all of that, Milods, requires considerable analysis by an administrative body. And in my humble submission, Milods, it cannot be decided in the writ proceedings of such nature. So, and in that regard, Milods, I may just bring, I may just place a judgment compilation, because these aspects have been considered so many times by honorable courts. And if my friend can pass on that judgment compilation, which will bring certain clarity on this issue.
Yes. Have you given them copy? Mr. Hewitt?
Compilation of judgments? No, they have given us. No, they didn't give us. I got now.
Yes, please continue.
Yes. Whereas, if I may bring to the notice of this court the first judgment of this compilation, and thereafter I will also deal with the judgment which has been cited by my learned senior. The first judgment, Milods, is the recent judgment of the Honorable Supreme Court in the case of Union of India versus Indian Navy Civilian Design Officers. And Milods, may just see paragraph 1 to 4 are the facts of this case.
Yes.
With Miller's permission, I am reading paragraph 1 to 4, just to bring into the context as to what was the dispute. By way of the present appeal, the Appellant Union of India has challenged the judgment and order dated 2nd of August 2010 passed by High Court of Delhi in writ petition number so and so, whereby the High Court had dismissed the writ petition filed by the appellant and confirmed the judgment and order dated 8/6/2007 passed by Central Administrative Tribunal in OA number so and so. Para 2, the respondent, Indian Navy Civilian Design Officers Association, had by way of filing the OA number so and so before the tribunal challenged the decision of the appellant rejecting their representation for grant of pay scale of 7,500 to 12,000 to the junior design officers as allowed to the civilian technical officers, consequent to the implementation of the 5th Central Pay Commission. As per the case, the respondent association, the cadre of design officers in the Indian Navy, was created in the year 1965 in order to meet the functional requirements of Navy regarding specific assignments to naval dockyards, training establishments, Directorate of Naval Design, and other technical directorates of naval headquarters. The drawing staff in the Navy belong to diverse disciplines such as construction, electrical engineering, and armament. So far as the disciplines of construction, electrical engineering are concerned, Group B gazetted posts were designed as junior design officers, and armament disciplines and Group B gazetted posts were designated as civilian technical officers. Because the parity is being drawn between JDOs and CTOs herein. And thereafter, Milods may just see para 5 where the issue is crystallized at page 3. The main issue that falls for consideration before this court is whether the tribunal and the High Court were justified in equating the post of JDOs with CTOs and in fixing the pay scales of JDOs equivalent to that of CTOs. In utter disregard to the legal position settled by this court in Catenau decisions to the effect that court should not interfere with complex issues of evaluating the nature of duties and responsibilities of posts and of fixing the pay scales with which task otherwise is best done by expert bodies like the Pay Commission. My lords, thereafter, certain factual aspects have been.
See, Mr. Pandey, as far as the petitioner is concerned, in paragraph 5, what distinction can you make? What distinction can you make between the nature and work of a Mali and a Mali?
Yes, my lords.
For example,
my lords, here, yes.
See, that's what you want
my
to
lords,
say.
Here the situation is that merely the post, as far as contractual employees and the employees which are in regular cadre having the same nomenclature is concerned, that would not itself mean that there is absolute identity of the work done by these two individuals.
That has been explained in the last column.
Belongs, they are saying that is a mere averment that they are doing the job of a Mali. But it may not cease at page 133 the nature of the appointment orders that they have placed, because they have to prove it beyond doubt that there is absolute identity. The nature of the appointment orders which have been placed are all showing that all are for the purposes of on need basis. They are made for a very short period of time and they can be terminated at any stage. So
that is not the issue.
My lords, what I am saying is that it is the responsibility of the petitioner. The onus of proof is on the petitioner to prove that there is absolute identity. And a mere averment, in my humble submission, that they are identical would not suffice. Secondly, the analysis has to be done taking into consideration various factors. It could be the nature of appointment, the qualifications of the persons who are appointed, the responsibilities attached. This is what the judgments will not clearly say, that merely, even if you are doing certain work which is similar in nature, that would not itself allow you to take benefit of equal pay and equal work. So all these factors, my lords, it is the responsibility of the petitioner to prove it beyond doubt before my lords. But that, my lords, unfortunately cannot be done by way of these writ petition, and it has not been done. The pleadings are insufficient. There is no possibility of any evidence being laid in these proceedings. So my lords has to consider all these facts, and this is not one post. They have to make their case good for all the posts which they are seeking parity. My lords, in this regard, just sees paragraph 9, because paragraph 9 is the conclusion of the court. Before adverting to paragraph 9 at page 5 of the judgment compilation, before adverting to the rival contentions raised by the learned counsels for the parties, it deserves to be noted that the power of judicial review of the High Courts in matter of classification of post and determination of pay scale is no more res integra. It has been consistently held by this court in plethora of decisions that equation of posts and equation of salaries is a complex matter which is best left to expert body unless there is cogent material on record to come to a firm conclusion that a grave error had crept in while fixing the pay scale for a given post, and interference of the court was absolutely necessary to undo the injustice. Because then para 10, state of UP versus JP Chaurasia is quoted, and thus I will read the quoted part, paragraph 18, which is at page 6. The first question regarding entitlement to the pay scale admissible to section officer should not detain us longer. The answer to the question depends upon several factors. It does not just depend upon either the nature of work or volume of work done by the bench secretaries. Primarily, it requires, among others, evaluation of duties and responsibilities of respective posts. More often, function of two posts may appear to be same or similar, but there may be difference in degrees in the performance. The quantity of work may be the same, but quality may be different that cannot be determined by relying upon averments and affidavits of interested parties. The equation of post or equation of pay must be left to executive government. It must be determined by expert bodies like Pay Commission. They would be the best judge to evaluate the nature of duties and responsibilities of posts. If there is any such determination by a commission or committee, the court should normally accept it. The court should not try to tinker with such equivalences unless it is shown that it was made with extraneous consideration, such as that is not the case here. Again, Willard's para 11 is Union of India versus Makhan Chand Roy is quoted, and I'll just read the quoted part, paragraph 12. We do not consider it necessary to traverse the case law on which reliance has been placed by counsel for the appellant, as it is well settled that equation of post and determination of pay scales is primary function of the executive and not the judiciary. And therefore, ordinarily, courts will not enter upon the task of job evaluation, which is generally left to expert bodies like Pay Commission, etc. But that is not to say that the court has no jurisdiction and the aggrieved employees have no remedy if they are unjustly treated by arbitrary state action. Courts must, however, realize that job evaluation is both a difficult and time-consuming task, which even expert bodies having the assistance of staff with requisite expertise have found difficult to undertake, sometimes on account of want of relevant data and scales for evaluating performances of different groups of employees. This would call upon a constant study of external comparisons and internal relatives on account of changing nature of job requirements. The factors which may have to be kept in view for job evaluation may include: 1. The work program of his department, the nature of contribution expected of him. 3. The extent of his responsibility and accountability in discharge of his diverse duties and functions. 4. The extent and nature of freedoms/limitations available or imposed on him in discharge of his duties. 5. The extent of powers vested in him. 6. The extent of his dependence on superiors for exercise of his power. 7. The need to coordinate with other departments. So, my lords, all these factors have to be kept in mind while making the assessment. And so, my lords, that is something that has to be seen. And it is my humble submission that, my lords, the petition itself, because the court itself quotes the judgment in JP Chaurasia and says that affidavit itself is not sufficient. Merely affidavit of an interested party saying that everything is similar is not sufficient. It's a very tedious exercise that has to be considered. And now Milord's job is even more onerous because the petitioner has asked a parity in respect of n number of posts. It's not one post. It is n number of posts which has been claimed to be having equal work. So, my lords, in this light, I may just indicate one more judgment of a recent judgment of the Supreme Court, which is at page 12, and one paragraph only. I will, because this judgment in itself covers everything, but one paragraph of the judgment at page 12 of State of Madhya Pradesh versus R.D. Sharma and another. My lords, this is a judgment of 2022, and paragraph 17, my lords, notes.
Yes. Para 17.
Para 17, my lords, at page 20.
Yes.
Para 17 below says, it may be noted that this court has consistently held that equation of post and determination of pay scales is the primary function of the executive and not the judiciary. Therefore, ordinarily, courts will not enter upon the task of job evaluation, which is generally left to expert bodies like the pay commissions. This is because such job evaluation exercise may include various factors, including relevant data and scales for evaluating performances of different group of employees. Such evaluation would be both difficult and time consuming, apart from carrying financial implications. Therefore, it has always been held to be more prudent to leave such tasks of equation of post and determination of pay scales to be best left to an expert body, unless there is cogent material or record to come to a firm conclusion that a grave error had crept in while fixing the pay scale for a given post, and that the court's interference was absolutely necessary to undo the injustice. The courts would not interfere with such complex issues. A beneficial reference of the observation made in this regard is made to Secretary of Finance Department, as held in state of Haryana versus Haryana Civil Secretariat. Equal pay for equal work is not a fundamental right vested in any employee, though it is a constitutional goal to be achieved by the government. So it's not a fundamental right which my learned friend is today claiming. And secondly, the courts have taken a consistent view that this has to be determined by the executive. It is very difficult for such things to be decided by courts. So, my lords, that is as far as the proposition that the court should not interfere in such matters, and it is best left to the expert bodies and executive to take a call on the parity of two posts is concerned. My lords, I will just highlight that as far as this combination of cause of action is concerned of various individuals by way of one writ petition is concerned, there are judgments to this effect, and I have placed those judgments in this judgment compilation. But just for ease, my lord, I am just reading from my counter affidavit. My lord, may I just have my counter affidavit? Those paragraphs have been quoted there for the ease of reference. We'll also just see page 6 of my counter affidavit. Affidavit filed by respondent number 2 and 3. And I'm reading, my lords, from heading B, writ petition is not maintainable in view of clubbing of multiple causes of action. That it is submitted that the petitioners have different causes of action in case of each petitioner candidate.
Sorry, you're reading paragraph?
My lords, I am reading page 6, heading B, and it starts with my lords, para 1.
Yes.
That it is submitted that the petitioners have different causes of action, and each of and case of each petitioner candidates contains distinct set of facts which cannot be clubbed into one petition. It is submitted that each of the petitioners has a distinct cause of action against the action of the respondent, and the aspect of whether they are entitled to equal pay at par with regular employees will be determined only after evaluating the existence of wholesale identity between the holders of two posts. For any such exercise to be carried out, the respective person is required to demonstrate the source of entry, the qualifications possessed, the manner of recruitment, etc. In the present case, an omnibus statement has been made by the petitioner association regarding equality in all respects without placing any material in support of the said assertion. It is further submitted by way of illustration that at least 20 members of the petitioner association have already been regularized. Since the said 20 contractual employees whose posts have been regularized are the landowner of a relative or relative of landowners who have donated their land situated at Umtru Barnihad, Reboy district for construction of new Umtru hydro project. In line with the office memorandum dated so and so, issued by Personal Administrative Reforms Department in the year 2020, the corporation has considered regularizing the appointment of the aforesaid 20 landowners or relative of the landowners who are already serving the corporation on contractual basis. Since the said landowner has objected the corporation from raising the water level to its maximum level, which in turn was affecting the power generation capacity of NUHP project, the issues have been pending since 2012 and to 20. Therefore, having no other alternative, the corporation has allowed a one-time settlement mechanism for regularizing the posts of certain contractual employees who are the landowners or relative of the landowner in line of the aforesaid notification of the state government. The petitioner association has not disclosed these facts, which brings home and cements the fact that this is not a fit case for consideration in representative capacity. This is a representative through an association. This position is also buttressed by following cases. These cases are quoted: Binod Kumar versus State of Jharkhand. In the case at hand, the writ petitioners who are working as para teachers are claiming their respective absorption in the service as permanent regular teachers. In our view, all of them are claiming their individual rights, and there is no dual relationship between the writ petitioner. Their cases can be of a similar interest but not of a common interest. As mandamus has been sought for their individual absorption in service, it cannot be held that they are pursuing a common and joint interest or a class as a whole. Rather, they are pursuing their own interest. Therefore, it has to be understood that they are pursuing their individual relief, although they may have similar interest. In our considered view, the petition shall be deemed to have been presented on behalf of each petitioner separately. So, that is the case. They have to separately present that because it is impossible for the court to make an omnibus determination of their claims. And similarly, two other judgments, even a Supreme Court judgment is quoted in these paragraphs. So that is my submission, Milods, that firstly, they have to come individually. Secondly, Milods, this determination has to, deference has to be given to the executive as far as equation of post is concerned. Thirdly, Milods, I may just distinguish the judgment of Jagjit Singh because it is in fact in my favor, not in favor of my learned senior colleague. So, Milods may have just the judgment of Jagjit Singh, and I may highlight para 9 first. Milods may have para 9.1. And all these cases have been affirmed by the court. Now, para 9 quotes all India Customs and Central Excise Stenographers versus Union of India. I will not read Milods the factual part. Just Milods sees para 9.3.
Yes.
While adjudicating upon the controversy, the court arrived at the conclusion that differentiation of pay scale was not sought on the basis of the functional work discharged by the petitioner and their counterparts in the secretariat, but on the dissimilarity of their responsibility, confidentiality, and relationship with the public. It was accordingly concluded that the same amount of physical work could entail different quality of work, some more sensitive, some requiring more tact, some less. It was therefore held that the principle of equal pay for equal work could not be translated into a mathematical formula interference in a claim as the one projected by the petitioners at the hand of a court would not be possible unless it could be demonstrated that either the differentiation in the pay scale was irrational or based on no basis or arrived at malafide either in law or in fact. In the light of the stance adopted by the respondents, it was held that it was not possible to say that the differentiation of pay in the present controversy was not based on a rational nexus. In the above view, the matter of the prayer made for the petitioners were declined. Similarly, my lords, even all these judgments which has been cited from paragraph 7 to paragraph 24 of Jagjit Singh, my lords, support me. Even if my lords sees para 10, where JP Chaurasia is quoted. My lords may just see 10.3. I am just highlighting the important part. While answering the first 10.2, my lords, see the two questions have been posed. The court, while adjudicating upon the controversy, examined the matter from two different angles.
Yes.
Firstly, whether bench secretaries in the High Court of Allahabad were entitled to the pay scale admissible to section officers. Secondly, whether the creation of two grades with different pay scales in the cadre of bench secretaries, despite the fact they were discharging the same duties and responsibilities, was violative of principle of equal pay for equal work. Now 10.3 words. While answering the first question, this court felt that the issue required evaluation of duties and responsibilities of respective posts with which the equation was sought. And it was concluded that on the subject of equation of posts, the matter ought to be left for determination to the executive, as the same would have to be examined by expert bodies. It was, however, held that wherever it was felt that expert bodies had not evaluated the duties and responsibilities in consonance with law, the matter would be open to judicial review. And in the present case, while acknowledging that one time bench secretaries were paid more emoluments than section officers, it was held that since successive pay commissions and even pay rationalization committees had found that section officers performed more onerous duties bearing greater responsibility as compared to bench secretaries, it was not possible for this court to go against the said opinion. As such, this court rejected the prayer of the bench secretaries as of right to be assigned a pay scale equivalent to or higher than that of section officer. So, my lords, the court is again highlighting that we have to identify the nature of the duties and the responsibilities attached with it. So that determination court is saying that it is best left to the executive. So again, these judgments, my lords, I can go on and on, but all these judgments.
So you are going to the micro issue.
Yes, so just briefly, one or two more paragraphs of this judgment, and then I will not bother your lordship as far as this judgment is concerned. My lords, just paragraph 42, where the conclusion of the court is, and which was also placed reliance upon by the learned counsel on the other side.
Yes.
My lords, may just see before paragraph 42, it begins with the heading, the consideration. So after quoting all these judgments, the court has considered that and come to certain deductions. So my lords, may just turn to internal page 206, where the deductions are. So I am not taking a lordship to the preliminary paragraph. Just 42.1, my lords, it says our consideration has led to the following deductions. So these are the deductions. Now, my lords, may just see 42.1. It says that the onus of proof of parity in the duties and responsibilities of the subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it. he who approaches the court has to establish that subject post occupied by him requires him to discharge equal work of equal value as the reference post. So the onus of proof is placed on the petitioner, and he has to prove it beyond doubt that the posts are having equivalence. And my lords, in this regard, I will just bring to your lordship's attention also 42.3 from the conclusions only. The principle of equal pay for equal work applies to cases of unequal scales of pay based on no classification or irrational classification. For equal pay, the employees concerned with whom equation is sought should be performing work which, besides being functionally equal, should be of the same quality and sensitivity. So that is also a condition that the petitioner has to establish before making this claim. And very importantly, Millard's para 42.6.
Yes.
For placement in a regular pay scale, the claimant has to be a regular appointee. The claimant should have been selected on the basis of a regular process of recruitment. An employee appointed on a temporary basis cannot be claimed to place in the regular pay scale. So that is also one of the conclusions that the court has come to, that there has to be a regular appointment. And clause 42.8 also. If the qualifications for recruitment to the subject post with reference posts are different, it may be difficult to conclude that the duties and responsibilities of the post are qualitatively similar or comparable. In such a case, principle for equal pay for equal work cannot be invoked. So even qualifications have been taken into consideration by the Honorable Court in coming to a conclusion for equal pay and equal work. And lastly, my lords, last paragraph of this judgment, I will just place reliance on the last paragraph, para 60, last third paragraph, my lords, at page 224, internal page 224.
Yes.
Because, my lords, this case, as far as the facts of this case is concerned, this case turned on its facts, and that is why, my lords, that judgment, as far as the factual aspect is concerned, it may not be applicable. Just paragraph 60, my lords, it says that having traversed the legal parameters with reference to the application of principle of equal pay for equal work in relation to temporary employees, daily wage employees, ad hoc appointees, employees appointed on casual basis, contractual employees, and the like, the sole factor that requires our determination is whether the employees concerned before this court were rendering similar duties and responsibilities as were being discharged by regular employees holding same or corresponding duties. This exercise required the application of parameters of the principle of equal pay for equal work summarized by us in para 42, which Milos has just seen. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual position. We say so because it was fairly acknowledged by the learned counsel representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were available in the regular cadre establishment. It was also accepted that during the course of their employment, the temporary employees concerned were being randomly deputed to discharge duties and responsibilities which at some point in time were assigned to regular employees. Likewise, the regular employees holding substantive posts were also posted to discharge the same work which was assigned to temporary employees from time to time. There is therefore no room of doubt that the duties and responsibilities discharged by the temporary employees in the present set of appeals were the same as were being discharged by the regular employees. It is not the case of the applicant that the respondent employees did not possess the qualification prescribed for appointment on a regular basis. Further, it is not the case of the state that any of the temporary employees would not be entitled to parity on any of the principles summarized by us in para 42 herein above. Therefore, there can be no doubt that the principle of equal pay for equal work would be applicable to all temporary employees concerned, so as to vest them in the right to claim wages at par with the minimum scale of regularized employees holding the same post. So on the facts of the case, State of Punjab had conceded that aspect, and that is why the court did not go into a determination of whether parameters as highlighted in paragraph 42 of this judgment are met or not. Such is not the case here. We have in paragraph 14 of our counter affidavit taken a categorical stand that these posts are different, and there is no parity as far as the work done between these individuals who are holding these posts. So, my lords, as far as the facts of the case, on the facts of the case, the judgment of Jagjit Singh was different. But as far as the legal aspects are concerned, from the paragraph 42 and the judgments which are quoted before that, all judgments, my lords, are in my favor. So with that, my lords, I conclude my submissions.
My lord, a very quick rejoinder, my lord, just 2 minutes. I must be thankful to my friend for referring to paragraph 60, my lord. Now he says the honors is on me. Honors is on me. So paragraph 5 of my read petition, what did I say? Just very quickly I'll read, my lord. That the members of the petitioner are appointed in a sanctioned post, which posts are also available in regular cadre. The nature and responsibility of work are same for both. A comparison of the posts between the nature and the responsibility of work illustrated herein below. What did they reply? Paragraph 19 in their affidavit in opposition. They replied in paragraph 3 and paragraph 4. They said the contents of the corresponding paragraph merits no response as a matter is a matter of record.
Just a moment.
Paragraph page 19, my lord.
You see paragraph 19.
Page 19, paragraph 3, my lord.
This is with reference to your paragraph 5.
Yes, with reference to my paragraph. They have to clarify that one, because paragraph 5 there is no mention of the specific advertisement. So we assume that this is what they reference to.
Because that may not be factually correct, because if the Lord sees paragraph, just the preceding paragraph, because I think by inadvertence the paragraph number has been omitted as to what is being replied to, and that is why that has come. But just before, because paragraph 4 has been repeated in reply. At page 19, Milord will see 2 paragraph 4s due to certain error. But just before the reply to paragraph 6 and 7, because the paragraph says the reply to the amendment made in the writ petition and answering respondent begs to state that several action has been taken by the corporation in the interest of contractual employees working for the corporation. However, instead of appointing them on 59 days or 90 days, corporation in the year 2012.
Sorry, you're referring to which para?
Page 19.
Page 19, yes.
Page 19, para 5, my lord.
Para 5.
Because, my lord, code copy must have been corrected. Whereas,
my lord, what I wanted to say is they have replied. They have just a second, my friend. They have replied to paragraph 2 of my affidavit in opposition. If my lord comes back little to page 17, my lord. They have replied that in reply to paragraph 2 of the writ petition. Now my lord comes to page 19, which they said they have made a 2. But anyway, now straight away they come to that in reply to advertisement made in para 6 and 7. So which means that para 3, 4, 5 has been admitted. So this is what they're saying, paragraph 3, page 19. They're saying that the contents of the corresponding paragraph merits no response as the same are matters of record. So that's my case. They have admitted themselves Now, on the face of the record, they filed an affidavit. It says that when I say that I have been appointed on a sanctioned post, they said it's a matter of record. I say that you have deprived me, the Mali post is there, even existed in your regular post also, nature of work is same. You are saying, yes, it's a matter of record. So what else proof they want from me? They themselves has admitted. It's on the record. And now when I'm saying at paragraph 6, look, you are paying to a Mali this much amount and to me this much amount. And they're saying that no, we have taken lots of this thing, and your claim for regularization is not tenable. I've never asked for regularization. So it is an evasive denial. Now, evasive denial, my lord knows, evasive denial is nothing but it's an admission. So, my lord, now, finally, my lord,
point out on this issue. I'm not arguing anything. I'm just pointing out the relevant paragraphs.
Just a moment. Let him finish.
Yes, just a second, my friend. And then now, my lord, there was an affidavit, an additional affidavit which I brought on record, my lord. This affidavit was filed on 3rd December 2023, my lord. There's a small affidavit, my lord. My lord has that affidavit. My lord, kindly look at page.
Just a moment. 3rd December. 3rd December or October?
This is October, my lord. 3rd October, sorry. 3rd October. This is an affidavit, my lord.
Yes.
This is a circular, my lord, passed by the Director of Corporate Affairs, my lord. And type copy is at page 6, my lord. May I read, my lord?
Yes.
This. The management has observed that there are casual/contractual workers of MEECL, MEPGCL, MEPTCL, and MEPDCL who are in service under the corporation who have crossed the age of 58 years. It is therefore mandatory that the casual contractual workers are to retire from corporation service at the age of 58 years with immediate effect, and all controlling officers are to keep track of records of all the casual/contractual workers who are to attain the age of superannuation and to issue notice 3 months prior to the date of retirement. The concerned casual contractual workers are to inform the office of the Directorate Corporate Affairs, MECL Shillong. Henceforth, all casual contractual workers are to adhere to the retirement age as prescribed for regular employees. The issue with approval of the chairman come managing director. Now, even in the case of retirement, my lord, we follow the rules, the retirement rules, my lord. And my lord, the two judgments that my friend has previously pointed, my lord, that has no relevance with this thing. He is, the MECL misunderstood, my lord. It's not my case that where I'm saying that I am a Mali and I want a please pay scale of the LDA. Those cases pertains to two posts trying to amalgamate and saying that since these people are different posts, they're having this scale. I also want that scale because my job is very similar. Those are the judgments. And the second case, which 2023, this regards to PCCF. Upgradation and pay and all these different grievances raised by two sections, my lord. So I'm not saying that. I'm saying here is, since I'm a Mali, you have a Mali, and we two are doing the same nature of work, therefore you are paying to him, at least pay to me the minimum regular which the Supreme Court mandates. I'm only asking for that much right. I'm not asking for regularization. And here the opposition, the objections, the counter objections that have been raised is as though I am asking for regularization, which is not. And they're saying that no, you have to prove it. That Mali, you are doing the Mali job. And when I'm saying that, they say that it's a matter of record. Whereas just because a judgment says that I need to prove. Not necessarily when you have already admitted and say that is a matter of record. So what else? And when I'm saying paragraph 6, say you have deprived me this much pay, they're saying no, you're not entitled to regularization. Who is asking for regularization? So which means, my lord, here it's a open and shut case. Open and shut case. They have admitted I am a Mali, they have a Mali, they are paying me pay which is far below the permanent or the pay scale available to the permanent employees, my lord. Oh, that is all, my lord. All right.
Just one paragraph I may just point out, because that we have taken an objection to all of this. Page 12, para 3. Just note that paragraph, that I need not argue any further.
Page
12, para 3.
Yes.
The post of electrician, meter reader, cum clerk, and jugali posts were large in numbers, who are the maximum number of women are being recruited beyond the sanctioned post purely on need basis, depending on the requirement of the job and jurisdiction. Hence, the claim of the petitioner is false and baseless.
No, I don't think this will help. I don't think this will help you.
Well, what I am saying is that all these aspects have been controverted in detail. The merely certain paragraph is missing in paragraph-wise reply. I don't think so. That will amount to any admission. And we'll also see just from page 11 also, the writ petition has been based on incorrect facts under the heading C. It says that the petitioner association has failed to disclose that the contractual employees of corporation are appointed. I'm reading page 10, last two lines. Last two lines under the heading writ petition is based on incorrect facts.
Yes, see.
The writ petition association has failed to disclose that the contractual employees of the corporation are appointed on a need basis, and they are appointed for a period of 1 year on the basis of the contract agreement. So the nature of employment is completely different. The pay of contractual employees are being fixed and paid from time to time on the basis of the notification issued by the Labour Department of Government of Meghalaya in line with the Minimum Wages Act, depending upon their skill and ability. So it's a completely different set of, and then what we are doing for them is also mentioned. Further, in addition to the set payment, the corporation has also extended the following facilities. Enhancement increment in salary with effect from 2018 based on the experience tenure of service of the casual employee in MECL and its subsidiaries as below. Percentage of enhancement of wages of the employee whose tenure of service is above 5 years but below 10 years is fixed at 5% of the total amount of monthly wages. Percentage of enhancement of wages of employees whose tenure is 10 years but below 15 years is fixed at 10% of the total amount of monthly wages, and percentage of enhancement of wages of the employee whose tenure is 15 years but below 20 years is fixed as 15% of the total amount of monthly wages. Then further additional benefits are enumerated. So below they are being the benefits are of casual leave, earned leave, maternity leave, and the protections under the EPF Act. So what we are saying is that your nature of employment is completely different under the contract. Still, certain protections have been provided to you, and you've been treated completely differently. So that is my submission, was that that aspect has been controverted fully in the writ petition and reply to the writ petition. So that may be taken into consideration by deciding this case.
Obliged, Rashid. Obliged.
Can you file a brief written synopsis of your
Yes,
argument?
yes, Lord, we will file. We'll file, yes.
Yes.
How soon can you do that?
My lord, I'll file.
1 week?
1 week, my lord.
1 week, Lord. 1 week.
My lord.
1 week we'll file.
Obliged.
Parties are heard in this matter. However, it is submitted that, however, it is prayed that brief written synopsis of the argument advance before this court today will be allowed to be filed in due course. On premier, the same is allowed. This is matter up to 1 week. Thank you.
Item number 10.
Promotion matter?
My lord, that's a DPC.
Yeah, DPC.
That DPC.
It was heard already.
Partially.
It was heard a long time back, my lord.
Hmm?
This matter was heard some time back, maybe last year.
Already heard?
My lord, partially it has been heard when my lord then the DPC was called by my lord, where the two DPCs was held.
You mean the records we called for?
Record the DPC proceeding.
Have it been produced?
It has not been produced, my lord. Well, we'll produce it, my lord, because it was heard in the month of August last year, my lord.
Exactly. So now you have to again refresh the court.
And if necessary, if the matter is heard, my lord, if records are necessary, we'll place it.
It is necessary, my lord. By that, the promotion was denied by the petitioner. What was the finding of that DPC, my lord?
No, whatever the finding of the DPC,
That has a bearing on this.
That would have been brought on record by the respondents.
Yes, ma'am.
I'll keep the records handy, my lord. When the matter is heard, if
In
it's
case
required,
it's
I'll
required to
place
be for reference. How long?
So,
After 2 weeks?
as it,
2 weeks. On premier with the parties. This is matter of the 2 weeks.
Item number 15.
Lordship, we are supposed to file WA today, but we are seeking some more time to file our WA, Your Lordship, because the conducting counsel was on leave till yesterday and we couldn't file it.
Oh. Have you filed yours?
Yes, Your Lordship.
And for the respondent number 123.
There are counsel for the respondent 123 has sought for some more time to file the written argument on the ground that the same has not yet been prepared. On premier, the same is allowed. This is matter after 2 weeks.
Obliged.
Item number 16.
Lordship, it is with regards to the arbitrary suspension of my arms license. The pleadings are completed, Lordship. It's ripe for hearing.
So,
We'll
take it up in the second half then?
Second half, Lordship. Take some time.
So at 2 then?
Lordship, at 2.
Yes, Mr.
2 weeks then. I'll take half an hour. 2 o'clock, Lordship.
So we'll take it up at 2 then?
Lord, I crave my Lord's indulgence. My Lord, this matter. My Lord, item number 3.
Oh, not this one.
Not this one, my Lord. I'm making a prayer, my Lord. Item number 3, which was listed at the end of the board, my lord.
Item number 3.
This is hearing, my lord. That's sports council.
Main list?
Main list, my lord.
Yes.
My lord, firstly, my lord, I am not keeping well today. So, my lord, I am praying for some time. In the meantime, my lord, I have requested my learned senior, my lord, he has relied on file some additional affidavits, which of course I do not have a copy of those, my lord.
At this stage, my lord, we find this asked.
Look, yes, my lord, because the copy was never supplied to me, my lord. The fact remains it was never supplied to me, my lord.
You have not supplied to me?
No, never, my lord.
We are respondents, my lord.
Of course, but my lord, I'm a state respondent.
Respondent with cross purposes.
My lord, I'm a state respondent, and definitely I'm supporting the.
It appears that is the case.
Yes.
Because here the petitioner and the respondent number 3 are the same person.
But since the case is filed by the sports council, my lord, I had to be made a respondent. I'm the respondent. But however, I never received any of the copies, my lord. It is a fact. Otherwise, I would not have requested.
My lord, let it be on Tuesday as a final line. On Wednesday, I'm leaving.
My lord, I'll my lord, request for at least 2 weeks, my lord.
But at this stage,
Because my lord will kindly appreciate, I have never sought for time before this honorable court, my lord. Only on the last occasion, my lord, I had I had made some submissions, my lord. On that day also, I pointed out, my lord, that none of the documents are available with me.
Please understand.
That being so, my lord, I am only requested for 2 weeks.
Please understand the
Yes, my lord.
fact that this is a very, very long pending matter.
Yes, my lord. And my lord will see, my lord, in the orders also, there is not a, my lord will hardly see any day where I have made a mention, my lord, seeking time from this honorable court. So that's why I am praying for 2 weeks time, my lord.
Now you're seeking indulgence. Next day, somebody.
No, my lord will kindly appreciate, because firstly I have stated I am not keeping well, my lord.
That of course. As far as today is concerned, well.
My lord. Secondly, my lord, because none of these records are available with me, as in whatever is before this honorable court, my lord. So at least I will also go through it, my lord, before I make.
Well, I pray that let it be on Tuesday.
Tuesday I have. Then, my lord, if my senior is, let it be taken up as and when my senior is back, my lord.
I'm pressing for Tuesday.
Tuesday it will not be possible for me, my lord.
Why? When will you be back?
I'll be for a month.
Too long.
I'm going for treatment.
So, my lord, may I request that let it come after Tuesday, after 2 weeks, my lord. In the meantime, I may make my submissions, my lord. Subject, my lord, as and when my senior is available, he can respond, my lord.
Your junior colleague will be here.
He'll be here.
Yes, my lord.
Because as far as you are concerned, you have
Yes, my
already
lord,
said
their
your
submission
piece.
is over.
I don't think there's much.
My junior colleague may write down whatever I am stating, my lord. Subsequently, it can be responded, my lord.
See, if it is not too inconvenient to you, wherever you are, if it is required to respond, you can do it by VC.
Yes, my
I
lord.
don't think there's a problem.
Well, this cannot go on.
No.
My lord, this is the first time I am seeking time, my lord.
I don't know. This matter, see, a matter has been pending from 2016, and now you're saying that this is the first time.
No, my lord, my lord will kindly check the records, my lord. Which is the day where I have sought time,
He
my
does
lord.
not even know that the records are here. The last occasion he has said that call for records. The records were called in 2016.
This will be the last date, and no more adjournment will be allowed.
Yes, my lord.
Not even a whisper.
My lord.
When the matter was called up for hearing, accommodation was sought for by the Leonard G appearing for the state respondent on the ground of personal inconvenience. Though this court has time and again pointed out that this matter is a very long pending matter and requires to be heard expeditiously, yet for reasons mentioned, the matter was adjourned from time to time. Be that as it may, on grounds of personal difficulty, the court would allow the prayer made. It is, however, made clear that no further adjournment will be allowed in this case, and all their counsels appearing for the parties are requested to make prior accommodation as far as the hearing is concerned. On pre-made, this is matter after 2 weeks.
Second call from supplementary list, item number 3.
CBI matter, my lord. This is also a long pending matter. Today I don't think time will permit, my lord. We can have any day, my lord. Tomorrow, day after tomorrow is convenient for it.
How many respondents are there?
There are 5 respondents.
Is
my
that
lord.
NEHU matter? Or NEC
No,
matter?
NEC matter.
Yes, my lord. Discharge. They have come revision against the discharge. So let it be tomorrow, my lord. This is one of the
Discharge. All the accused.
all the accused, all the 5 accused have been discharged. And there is an order, my lord, 16/5/2019, my lord. There was an order passed then by Justice Yaqub Mir, and then he has formulated some issues here, my lord. Now the paragraph 9, just for this. Now the question is as to whether the learned trial court has appreciated the matter in right perspective. That is, as to whether satisfaction of the court of the learned trial court genuineness and unimpeccable character of the documents has been looked into. This is the only issue, my lord. This is the only issue. So what had happened, my lord, was they have charge sheeted against the 3 officials. And they were yet to charge sheet against the private 2 respondents. They are the principal and the vice principal of the St. Peter's College, purportedly the beneficiaries of the scheme, my lord. When they filed a charge sheet against us, an application was moved before the court saying that certain documents were not, whatever documents were seized, entire documents was not annexed at the time of filing the charge sheet. And when you look into all these the documents that has been seized, it will go to show that there is no case.
Anyway, we'll not go into that now.
My lord.
Since he has sought for time.
Yes, because that is only thing, my lord. Now
it is quite a voluminous matter, my lord.
But it's a voluminous matter, but the issue is very small, my lord. It can be decided in 30 minutes, my lord.
We'll try to center.
Yes.
At the to the point.
Yes.
Issue involved.
Yes, my lord.
Yes.
Already the issue has been framed, my lord. Already what to look into. So that's a 30-minute, voluminous, but 30 minutes, my lord, at the most. Friday. Tomorrow is Friday. No, Thursday. Thursday. Tomorrow.
We'll have this matter on 3rd.
Third, my lord. 3rd.
On pre-made by the parties. This is matter on 3rd.
Second call from daily list, item number 4.
Lord, if this matter is taken up any day next week, my lord.
Yeah, in fact, matter was heard.
In fact, it's heard, my lord. On some point, some clarification was there. We have filed an affidavit, my
In
lord.
the course of the hearing, my friend has raised that as per Rule 20 of the RTE rules, that there is a provision for a constitution of tribunal. With that aspect, my friend has filed the affidavit saying that there is no tribunal as per the rule, because the government did not constitute a tribunal. But still, my lord, the matter was heard, I think, last year, July, August, last year, lordship. So just for 10-15 minutes, I'll not take much time, Lordship, just to refresh the memory of the court. Otherwise, I will stick to my written submission.
Written submissions have been filed by all the parties, my lord.
Then let it on 7, Lordship. Next week, after 10 days, that's 7, because other any day on only on 7, Lordship.
Except on 7?
No, on 7, Lordship. Because next week,
7th, eh?
7th is fine.
On premier by the parties, this is matter on 7th. So we resume at 2.
Item number 16.
May Lordship. Lordship, I am a retired IPS officer and I have put in over 36 years of service in the force. Among the several posts that I have held, I have also been the Director General of Police Meghalaya for several years. Now, Lordship, in the year 1998, an arms license was issued to me at page number 15, Annexure 1, Lordship.
Yes.
Lordship would see at this
Yes.
heading under license details.
Yes.
On the right hand side, license number, second would be issue date,
Yes.
20/10/1998, and last valid up to is 31/12/2021. Lordship, it's a admitted fact that license, though issued in 1998, did not come with a validity of up till 2021. Periodically, every 2 years or 3 years, as the law prescribes for a maximum period of 5 years. But Meghalaya, we follow the procedure of every 2 years, if I'm not wrong. Sometimes 3 years, the license gets renewed. Accordingly, Lordship, in the year 2021, when my license was approaching the expiry and had to be renewed, as was being done since 98, I had put in my license, and astonishingly, Lordship, to my surprise, the Deputy Commissioner passed an order whereby my license had been suspended. Lordship, Annexure 2, page 16.
Yes.
If I may, Lordship.
Yes.
Lordship, this was on the 19th of May 2023. The order comes, it reads, subject application for renewal of arms license. With reference to the subject cited above, and as per police report received that you are involved with Rinja PS case number 16-3 of 2007 under section 302 IPC. Therefore, under section 14.3 of the Arms Act, read along with section 17.3b of the Arms Act, it is required that you deposit the arms weapon at your respective police station. The license will be temporarily suspended pending the decision of the trial court. Renewal of your license is subject to after the cases are dropped or dismissed by the court. Lordship, the law expects, Lordship, license in case of weapons which are of the non-prohibited in nature, that is, ones which civilians can hold. License should be granted. And my case is not about not granting the license to me. It is about the renewal of a license which I have been holding. Now, Lordship, it says that I am involved in a Rinja PS case number 16-3/2007. I have said I am not involved in this particular case. I am facing prosecution in a case. We have mentioned the details of it. I'll come to it as I continue my arguments, Lordship. So now, Lordship, this order, as is required by law, it has to be a speaking order. Lordship, speaking order would be an order which shows that there has been an application of mind, and the authority who is empowered to renew my license has applied its mind, and after that it comes to a conclusion which seems to be satisfactory that no, this license cannot be renewed. Lordship, continuing further, against this order, I wrote a representation, Lordship. That was not paid to any heed. I wrote a second representation, Lordship, at page 22, annexure 4. Now, this second representation was also kept by the authorities. Page 22, Lordship, annexure 4.
This is the second representation.
Second representation. Now, Lordship, since no response was coming from the authorities, I filed an appeal, Lordship. Annexure 5, page 30. To the Home Secretary.
Yes.
Lordship, post my filing of this appeal, the Deputy Commissioner disposes of my second application on the 7th of October, Lordship. That would be Annexure 6, page 37, Lordship, and the type copy is at page 37A.
Yes.
If I may, Lordship.
Please.
Now it says, with reference to the subject and your petition cited above, this is to inform you that as per the police report and the views from the Advocate General of Meghalaya, renewal of your arms license is subject to after cases are dropped dismissed by the court. Therefore, under section 14(3) of the Arms Act, read along with section 17 3B of the Arms Act, it is required that you deposit the weapons. My weapons are deposited, Lordship. There is a challan to it, annexure 7, page 39. I have deposited my weapon. Now, Lordship, when we see the two orders of suspension, the only difference which comes out is that based on an opinion. Now, law requires an independent application of mind by the authority who has been empowered to renew my license, as I have stated, Lordship. Now, Lordship, they filed an affidavit. Lordship, we come to para 6, para 7 and para 9, read jointly. They are vehemently saying again that I am involved in Rinja PS case number so-and-so under 302. When I have categorically stated before them, when I had filed the application, that no, I am not involved in such case. I am involved in Sessions case number 76T of 2013, wherein the charges have been framed against me under section 201 and 203, Your Honor, not under 302. Not only are they trying to label a case on me where I have not been charge sheeted or I am not involved, but a section so heinous as 302. Now, Lordship, what is to be seen is this particular case was charge sheeted in the year 2007.
Do you have the particulars of this case?
Yes, Lordship.
Where is it? That 302?
Lordship, they have filed. They have in their application where they have suspended my license. They have said that I am involved.
That was the reference that you are involved in case under 302.
Lordship.
But you say you have not been. You are not involved.
No, Lordship. Lordship,
so you have not been read as a. You have not been implicated as a accused there.
As a murderer, I'll rather use the word, Lordship, under 302.
Accused. Yeah. You are
Lordship.
Until
Lordship.
But where is the details of that case?
Lordship, details of which case, Lordship?
Of the 302 case?
Lordship, that they have mentioned.
They may have mentioned, but it...
page 16 and page 37, Lordship.
No. Just... See, it says that you are involved in Rinja PS case so-and-so.
Lordship.
Now, this court would like to know the details of this as to who exactly is the accused here, or are there many accused person or only one?
Lordship, I am facing a prosecution in a case where one accused, not me, somebody else is facing charges have been framed against him. In fact, the charge sheet was filed against him under 302. Charges were framed against that particular accused, and that is a CBI case, Lordship.
No, we are looking at the reference here.
Rinja PS.
Yes.
Lordship, they will be in the position to produce the record if there is any such case where I have been charge sheeted and I am facing prosecution under 302. a Rinja PS case was taken over by CBI, first by CID and then by CBI. We don't dispute those facts. But Lordship, I am being prosecuted. Lordship, if the FIR was registered and the case was under investigation, they could have stated.
Your prosecution, the genesis of your prosecution, would it be this Rinja PS case?
Yes, Lordship. The genesis would be there. Now, Lordship, I have also, when I wrote my petition to them, I have stated that charges against me have been framed under section 201 and 203, and the charge sheet was also filed against me under section 201 and 203. Now, Lordship, the way I have been shown to be a criminal, why I am using this particular word, Lordship, I am an ex-IPS officer. I've served this state, and the law, in the eyes of law, Lordship, I am innocent until I am proven guilty. In their affidavit, they have stated that there are cases pending against me and I have a criminal background. Now, Lordship, if they had to suspend my license, the law expects them to not only pass a speaking order, but they should have given me an opportunity of being heard. They did not. They have mechanically suspended my license. Now, Lordship, they will have to come here and prove one thing. They will have to satisfy the court, Lordship, that from 2007 until 22 rather, what have I done which has made me a person suddenly who is unfit to hold an arms license, and secondly, a person who has become a threat to public peace and security. The ground, Lordship, they cannot suspend, revoke, refuse my license. The law is settled for any grounds other than the ones which are mentioned and contained in the Act itself. The Act does not say that if I have been implicated in a case, if I am facing trial in a case, that my license should be by default suspended. Had that mechanism been there, Lordship, by default it would have been suspended, as there exists a mechanism for conviction. That to the convicting court has been given that power. My case is, Lordship, that my license from 2007, from the time I am facing prosecution, till date, what have I done? Because the district magistrate, law expects the district magistrate to be satisfied that I might be somebody who is unfit to hold the license, or I am somebody who has become a threat to public peace. Because from 2007 till 31st of December 2021, I was not. Only when I gave my license for renewal, mechanically they say that I am a threat to public peace and security. Lordship, that is where my case rests, that they ought to have first satisfied themselves and then only they could have passed a speaking order, rather than passing a mechanical order that from police we have received a particular report, based on that your license is suspended. And when can it be again given effect to? When the cases are dropped by the court against you. Lordship, I am facing a trial where I have pleaded not guilty and I am contesting the case for the last 17 years, Lordship. From 2007 till 2024, last 17 years I am contesting that case. Now, either they say that my conduct in that particular case has been wrong. I have been trying to evade prosecution over there. That is not the case. I have been appearing there on each and every date. Lordship, the court over there could have passed that order. That is also not the case. Now, they will have to show how have I become somebody under 14.3 or 17.3b, either a person who is unfit to hold the weapon or somebody who is a threat to public peace and security. And I'm sorry, Lordship, but I have given my life, it's my career as an IPS officer, and I am being called a person of a criminal background. Now, Lordship, criminal background is somebody who is a habitual offender, who has been convicted in number of cases, who is facing trial in number of cases, and who is facing trial in number of cases of like nature also. So to make him a person of a criminal background, Lordship, their counter affidavit.
We have this said so.
Page 3, para 9. Lordship, if we may come to para 7 first, at page 3 of their counter affidavit. If I may, Lordship. Yes. At para 7 they say, third line, Lordship, from the third line, very casually they say, license of any applicant exclusively lies with the district magistrate who can exercise discretion, either to grant renewal or reject based on the compelling circumstances. Now, Lordship, either they will say, they are saying that there has to be compelling circumstances. Lordship, it's a very heavy word, compelling circumstances. It is something which will compel the district magistrate to cancel my license, though the law expects that in normal course, the license should be renewed. So, what are those compelling circumstances? Have I committed the same offence for which I am being prosecuted? Have I committed any other offence? Have I been party either in instigating or actively taking part in breach of public peace? They go on, Lordship. Third last line of para 7. In the instant case, the answering respondent has exercised his discretion in judicious manner and has rejected the application for renewal of the license, keeping in view the security of the public peace for public safety and security. So, that means they have credible information. That means they have satisfied themselves that I am misusing the weapon, or I may misuse the weapon, or I have misused the weapon, which is a reason for which the public peace and security is at stake. Because I am holding this license from 98, I am facing prosecution from 2007, and they did not cancel my license in a normal manner, Lordship. When I gave it for renewal, they cancelled it. And prior to this, it has been renewed. Lordship, they go on at para 9. Third last line, Lordship. The criminal cases are pending against the petitioner, cases, Lordship, which shows his criminal background and the respondent has rightly exercised his discretion in accordance with law. Para 10, again they say criminal background. They should have mentioned this in their order, Lordship, that I have a criminal background, that there are multiple cases pending against me. If I am a threat to public peace, they should have stated in that speaking, Lordship, that is when the order becomes a speaking order. They should have stated why am I a threat to public peace and how does the authority suddenly finds me to be somebody who is unfit to hold the license. Now, Lordship, these weapons which I am holding, these are on the previous occasion also I had submitted before your Lordship, they are wrapped and kept in the Malkhana. I am somebody who is experienced in handling weapons, taking care. They are antiques, Lordship. Lordship, if my license is only seen, Lordship, one is a double 12 bore, sorry, a double barrel gun, Cogswell and Harrington, and the other is a Belgian made .22 rifle. Lordship, section 13 and 14 also, if seen in spirit, says that weapons of double barrel and .22 should be granted. That is for granting of the weapons. The spirit of the law. Section 14, 15, 17. 17.5 says the order has to be speaking order. Lordship, it says that principles of natural justice have to be followed. I have to be given an opportunity of being heard to show cause. It has not been done. Arbitrarily, when I submit it for renewal, my license gets suspended. Now, Lordship, there are catena of judgments who speak on it. I will produce, my learned friend here will produce. But what boils down is that they have rejected my license. They have suspended my license, I'm sorry, Lordship, for me being somebody who has become suddenly unfit and somebody who is a threat to public peace and security. I did not have a case. Would they have done this in 2007, Lordship? But I am holding it and I have continued to hold it. So they will have to show that there is some act I have committed, because law does not give them the whip that anybody who is facing prosecution on a criminal case, his license should be suspended. Law is clear about it. So where we come down to, Lordship, they will what is expected of them of law, they have not done it. And in the affidavit also, the attitude which is seen is an attitude that we have the discretion, we can do it. There were compelling circumstances. What are those compelling circumstances? They don't know. They have not stated. Why have I become unfit? They cannot state. How am I a threat to public peace? They cannot state, because I am not. There has been no conduct which I have had in the past or since the time I am facing prosecution. So, Lordship, we have a compilation of judgments. Like I've said, Lordship, we can go to any lengths with the judgments, but what boils down to is that the order has to be one which is speaking, else it is not tenable in law.
That would be your main focus.
Absolutely, Lordship, because if they have been given a power, it comes with a duty.
Yes.
And Lordship, if we see both, if we use the yardstick of either Wednesbury's principle or Lordship, we use the principle of proportionality, the test of proportionality, their order fails, Lordship. Lordship, Wednesbury's principle says, Lordship, that if the decision is so outrageous that it defines the basic logic on which it is passed. Here the logic, as Lordship I have been arguing, is are the two acts which I have done for which you are cancelling my license, have I reached that category of being unfit? And Lordship, the principle of proportionality would state that can they use a hammer to break a nut? The order they are passing against me, is it proportional to any act that I have done? And that act has to be an act which is recent. So they will have to state that how have I been somebody who has become a threat to public peace, if they apply the Wednesbury's principle to it, and in the test in the principle of proportionality also, Lordship, they will have to state that how have I become unfit? Unless they cannot, Lordship. The period from 7 to 2021 is something which is in my favor. Lordship, I have a small gist of my written submission also in this.
No, you are citing this judgment.
Lordship.
But you have not given the particulars.
I am going to, Lordship.
What are the paragraphs you are relying on?
I am, Lordship. Lordship, 2016.
Yes.
I am relying at para 13, para 14.
This is
2016 SCC Online, Bombay 5019. The first judgment in the compilation, Lordship.
Yes.
The second judgment is 2018 SCC Online, Bombay 70.
Go first to this judgment.
Lordship.
Para
13, Lordship. 13. If I may.
Yes.
Lordship. It says, Lordship, the right of life and liberty are guaranteed under Article 21 of the Constitution of India. Arms license is granted for personal safety and security after due inquiry by the authorities in accordance with the provisions contained in Arms Act 1959. The provisions of the Arms Act with regard to suspension or cancellation of arms license cannot be invoked lightly in an arbitrary manner. The provisions of the Arms Act, particularly Section 13 to Section 17, indicate that once a license is granted under the Act, the same shall be renewed from time to time unless there exists a ground of refusal as enumerated under Section 14 of the Act. Lordship, Section 14, they have enacted 14.3 where they have said I have become unfit and thus I am, and the reason being that I am a threat to public peace and security. It goes on, Lordship. Protection of life, liberty of citizen is the responsibility of the state. It is only when persons apprehend that the machinery of state would not come to, Lordship, there they have gone to define various aspects. Para 15, nothing was placed before us by the respondents to indicate that the petitioner had misused the licensed weapon at any point of time in past. The order of revocation of license refers to 2 criminal cases registered against the petitioner. In the facts, we find that mere registration of criminal case or cases could not be a ground to revoke the license. Lordship, 2018, like I said, Lordship, even 18 and the 2022, the law is settled. It is saying that mere pendency of a criminal case cannot be a ground. The scheme of the Act from Section 13 to Section 17, it says that a license should be granted in an ordinary course. It says a license once granted is absolutely granted after a background check is done, and it should be renewed periodically in a normal course unless there are reasons compelling for the same. Lordship, 2018, second judgment in the compilation.
Is also Bombay.
Bombay, Lordship. Lordship, much data of the Supreme Court is not available with regards to these because the matters have normally been extinguished at the High Court levels. Page 10 of the compilation, Lordship, para 13. 2018 SCC online, Bombay 70.
Para 13.
Para 13, 14 and 15, Lordship.
Yes.
May I, Lordship?
Please.
Para 13 says, looking to the above provision, it is very much clear that the specific grounds have been mentioned in the said section on which the application for license would be refused. It could thus be seen that the discretion has to be exercised by the authority in accordance with the provisions of the Act. The license can be refused by the authority if the authority has reason to believe that the person applying is prohibited by the said Act or by any other law for the time being in force from acquiring, having in his possession or carrying any arms or ammunition, or if he is found to be of unsound mind or for any reason unfit for a license under the said Act, or where the licensing authority deems it necessary for the security of public peace or for public safety to refuse to grant such license. But it has to have a reason, Lordship. It cannot be mechanically be labeled. It goes on. Looking to the aforesaid provision of the Act, it is crystal clear that the authority shall not refuse the license other than the grounds mentioned in section 14 of the Act. No doubt the licensing authority can refuse the license to a person on the ground of security of public peace or public safety. On perusal of the reasons recorded by the respondent number 3 as well as respondent number 2, nowhere is it explained or mentioned in the order that the license is refused to the petitioner on the ground of security for public peace or public safety. On perusal of the provisions of subsection 2 of section 14, the licensing authority shall not refuse to grant any license to a person merely on the ground that such person does not own or possess sufficient property. Now, Lordship, what it is saying again is that the order has to be one which is a speaking order. The order has to be one which is a satisfactory order. So the authority has to first satisfy on the two grounds, that 14.3 and 17.3b. How am I or how will I be a? Same thing, Lordship, 2022 SCC, it's Rajasthan High Court.
Yes.
Lordship, what they have done is they have reiterated several judgments which were passed earlier, and based on that they have passed a one-line order. Para 2, (2020) SCC online 2022.
Para 2.
Para 2, Lordship. Page number is 2511. Para 2 and Para 3, Lordship, of this judgment. If I may, Lordship, it says, Lordship, we may come to page 12 because it's a repetition of judgments. Third para, Lordship. This was passed by the division bench. They have referred to within the judgment. Mere fact.
Yes.
It says, Lordship, mere fact that some reports have been lodged against the license holder is not sufficient for cancelling the license. A license can be revoked under section 17.3 if the licensing authority deems it necessary for the security of public peace or public safety. In the absence of any finding that cancellation was necessary for public peace or public safety, such an order is liable to be quashed. Lordship, they are very clear. See, merely mentioning that there is an apprehension to public peace and public security is not sufficient. There has to be a reasoning to it, Lordship. At the cost of repetition, Lordship, I'll read the last line. In absence of any findings that the cancellation was necessary for public peace or public safety, such an order is liable to be quashed.
Last line of
para 12, Lordship.
page 12.
Page 12, sorry. Mere fact
Yes.
That some of the reports. This is
The absence of yes.
They have quoted a judgment. The third last line over there, Lordship.
Yes, yes, yes.
Lordship, it very categorically says, because the scheme of the Act itself, Lordship, Section 14. Lordship 14.3.
Yes.
Where the licensing authority refuses to grant a license to any person, it shall record in writing the reasons for such refusal and furnish to that person on demand a brief statement.
Yes.
Section Lordship 15.3.
14.3 or 15.3?
14.3, 15.3 repeatedly, Lordship.
Okay.
The law, it is saying. May I, Lordship, 15.3?
Yes, please.
Every license shall, unless the licensing authority for reasons to be recorded in writing otherwise decides in any case, be renewable for the same period for which the license was originally granted and shall be so renewable from time to time. The provisions of section 13 and 14 shall apply to the renewal of a license as they apply to the grant of a license. Section 17.5, Lordship.
Yes.
Where the licensing authority makes an order wearing a license under subsection 1 or an order suspending or revoking a license under subsection 3, it shall record in writing the reasons thereof and furnish to the holder of the license on demand a brief statement of the same. Lordship, 17.7 is something of interest to us. A court convicting the holder of a license of any offence under this act or the rules may thereunder may also suspend or revoke the license. Now, Your Honor, the scheme of the act, in case of pending case, in case of any criminal prosecution going on,
Yes.
that is why the scheme of the act has used the word conviction. Only place where it finds mention is 17.7. If the authors of this act had the intent, they would have inserted a provision that anyone involved in any criminal case, it will be deemed that his license shall be suspended. However, Lordship, this cannot be possible because of the theory we follow is that we are deemed to be innocent until we are proven guilty. But it says, on conviction,
we have not reached that.
We have not reached. So what I'm trying to place before the court is that this law has been interpreted and law is settled that my license can be granted, revoked, altered, varied only as per the provisions contained in the act. They cannot come up with any provision which is not there in the act and do it. They have cancelled it, suspended it, saying that there is a criminal case pending. Law says that only upon conviction the court who has convicted me may cancel it. Nowhere does it say that if I have a criminal case pending, my license has to be by default suspended. But law empowers them, no doubt, to suspend my license also for certain compelling reasons. But those reasons have to be compelling, they have to be recorded, they have to show that there is satisfaction, they inspire confidence to pass the order. Mere taking opinions and passing an order, and they have improved their order, Lordship. First they pass an order, the opinion of AG doesn't find mention in place. Then again they give me the same order. There the mention of the opinion finds place. But But law doesn't say that somebody's opinion or any office's opinion is to be taken. Law says that he has to apply his independent mind. Because he has to be satisfied, either I am unfit, or I have somebody who will be a threat to public peace and security, or I am somebody who is both. Which does not, if we see their affidavit, Lordship, doesn't find mention. The judgments we have placed, they say that it has to be recorded, it has to have satisfaction. Mere pendency of a case is not something for which my license can be suspended, and my background has to be seen, Lordship. And if I have done something, they will have the record to show it. Why they suddenly can suspended it. Lordship, this is the case with which we are placing our arguments, and we have put forth the case. And Lordship, we humbly pray that seeing that the order is an order which is non-speaking, it doesn't inspire confidence. It has been passed mechanically. Be set aside, Lordship, and my license they be directed to renew my license with as per the terms and conditions of the Act rules and the applicable procedure.
You said you have prepared a written argument?
Lordship.
Yes.
I'll not much time, Lordship. Lordship, here is a case of renewal of license, Lordship. This is not a case of granting of fresh license, my Lord. I will come later what my learned friend has cited some judgment. I'll try to distinguish the judgment, Lordship. Although I have not access to the judgment, from his submission I could distinguish his judgment, Lordship. Here we are refusal to renew the license, Lordship. Although the officer has used the term suspend, it is not a case of suspension of license, Lordship. Now, Lordship, my friend has relied the document that is at page 15, Lordship, of his writ petition, Annexure 1, Lordship.
Yes.
The license, although the license was granted long years, Lordship, it has been renewed from time to time, Lordship. The last renewal was, Lordship, from 1/1/2019 to 31/12/2021, Lordship. Because the validity of the license got expired 1st of January 2022, Lordship. Because the validity were there till 31st December 2021. Now, after the expiry of the validity period, Lordship, my friend has put up the application for renewal of the license. Now, after receiving the application for renewal, Lordship, the district magistrate has sought for report from the competent authority, that is the superintendent of police, Lordship. And after receiving the reports, the report says that he is facing a murder charge, Lordship, before this honorable court at Shillong, Lordship. Based on these reports furnished by the superintendent of police, the application for renewal of license was rejected, Lordship. It is not a case of revocation or cancellation of the license. His license is still with him, Lordship. The authority did not revoke or cancel the license. Although the impugn letter speaks about suspension, but it is not a case of suspension. Suspension will come, Lordship, during the validity period of the license, Lordship. If during the validity period, if reports found, if the authority finds something adverse against the license holder, in that case, the authority can suspend or revoke or cancel the license. And in that eventuality, Lordship, what my friend is saying, that show cause as well as the passing of speaking order is required, Lordship. This is not a case of revocation or cancellation. This is a case refusal to grant. Now, what does the law says? That is at section 15, Lordship. My friend has relied, Lordship. Duration and renewal of license, Lordship. Section 15.
Yes.
A license under section 3 shall, unless revoked earlier, very important, Lordship, shall, unless revoked earlier, continue in force for a period of 3 years from the date on which it is granted, provided that such a license may be granted for a shorter period if the person by whom the license is required to or if the licensing authority, for reasons to be recorded in writing, considers in any case that the license should be granted for a shorter period. A license clause 3, Lordship.
Yes.
Every license shall, unless the licensing authority for reasons to be recorded in writing otherwise decides in any case, be renewable for the same period for which the license was originally granted, and shall be so renewable from time to time. The provisions of section 13 and 14 shall apply to the renewal of a license as the apply to grant of license. Here, Lordship, we are on issue of application for renewal of license and the rejection of the said application. It is not a case that the license has been suspended, license has been revoked or terminated. Now, what does section 14(3) say, Lordship? Because for renewal also they have referred that rule 13, section 13 and 14 will be applicable, Lordship. 13 say grant of license. Lordship, 13 say grant of license. That has already been granted, Lordship. That has already been granted. And 14 say refusal to license. Now suppose at the initial, Lordship, at the time of filing an application for granting a fresh license, if the authority refuses to grant the license, that in that eventuality, then the authority merely cannot refuse. He has to assign the reasons why he is threat to the public, threat to the public. What are the backgrounds?
So 14(3) speaks only to the period when the license is about to be granted.
Lordship, 14 talks about refusal. Now within 14(3) also, as per section 15 says that the authority can.
It relates only to the consideration of grant of license. Not when the license has already been granted.
Yes. Now again, as per section 15 says that in the case of renewal of license, yes, even then authority can take into note of section 14(3)
Can
of
take
the
recourse to the same formality which was done so under section 14.
14.
For grant of.
Yeah, for grant of
fresh
license. Yes, Lord. Fresh license. Now, that is with regard to refusal of grant of fresh license. Fresh license. Here, section 15, renewal of license. Now, in the case of renewal license, the authority is not required to issue show cause because we are not terminating his license. We are not revoking his license. It's a case of renewal, whether we will grant or not. That the discretion lies with the department. Why they cannot renew the license? Because they have to justify because of the pendency of the criminal cases. Now, whether pendency of the criminal cases can be a ground to refuse to renew the license, Lordship, I'll rely some judgment, Lordship. This is a division bench judgment, Lordship. 1999 SCC online.
Just a moment.
Nine SCC online, Bombay. Page number 50, Lordship.
50. Para?
Para, relevant para will be, Lordship, para 1. Then para 3. Then para 4 and 5, Lordship. I'll just read out, Lordship. The judgment is not that long, Lordship. Here the petitioner was granted for non-prohibited bore rifle so-and-so for a period of 1 year, that is up to 30th September 1991. The petitioner applied for renewal of the said license on 25/10/1991, that is after the expiry of the valid period, Lordship. After calling police report, the respondent number 2 rejected the application for renewal of license by order dated so-and-so. By this order, the petitioner was deposit the weapons either with the officer in charge of so-and-so, with the dealer holding the so-and-so, or this is, Lordship. Then the weapons are deposited by the same thing my friend has done, Lordship. The petitioner sought for grounds of rejection. The petitioner sought for grounds of rejection was informed by the letter dated so-and-so that the request for renewal of license was rejected on account of adverse police report. On account of adverse police record. That was the reasons furnished to the petitioner in that case, that your renewal has been, the department did not consider your renewal because of the adverse report given by the police. Now, Lordship, page number, para number 3. This is the submission of the state, Lordship. Yes. On the other hand, the learned government advocate Sri so-and-so has urged upon us that section 17.3, Lordship, section 17.3 talks about variation, suspension and revocation. Although the department has mentioned word suspension, but it ought not to have been, because it was not during the valid period, Lordship. Suspension, revocation or cancellation will come if the license was in alive. The license term validity has already expired. Now, of the act is not applicable. As such, there was no question of issuing any show cause notice before rejection of the request for renewal of the arm license. That no deeming provision can be carved out from section 13.2 or section 13.2a of the Arms Act. That the grounds on which the renewal of arm license was refused has been furnished, and in that view of the adverse report of the police, the respondent number 2 had properly exercised the discretion in refusing the grant of arm license. He also pointed out that the appellate authority, after hearing the matter, was confirmed the order, and there is no case for interference. Reliance has been placed on a full bench decision of the Patna High Court in so-and-so, wherein after examining the various provisions of the Arms Act, including section 13 and 14, it has been laid down that the discretion to grant or refuse the license in the context has perhaps been deliberately kept untrampled, and that if the authority has reason to believe that the applicant is for any reasons unfit for license, the license can be refused. Here the reason given because he was facing a criminal trial, Lordship. And in fact, all throughout, what my friend is saying that I have been, the license has been renewed from time to time. In fact, he has suppressed all those materials. Had the department known, because the license was granted long back, Lordship, had the department known, his license would not have been renewed. Or in between, after renewal, had it come to the knowledge of the department would have taken action as per section 17 clause 3, Lordship. Variation, suspension or revocation. As the learned counsel for the petitioner had himself asked before us that the application for renewal license has to be treated as fresh application. That was the argument, Lordship. Now, Lordship, para 5, the judgment of the learned single the petitioner was relying some judgment of the Allahabad High Court, Lordship. The judgment has distinguished here. The judgment of the learned single judge of the Allahabad High Court, on which reliance has been placed, has suggested that the grant of license can be subject to reasonable restrictions, which had to be judged not in the abstract but from point of revealing social conditions, which are referred to in paras 45 and 46 of the judgment. It may be pointed out that no such conditions exist in the state of Goa, and besides that, it is nobody's case that such conditions do exist in Goa. We cannot subscribe to the view adopted by the learned single judge that if an application for armed license is not disposed within a period of 3 months, it will be deemed to have been allowed after the expiry of 3 months. No such deeming provisions can be read into section 13 of the Arms Act. There was no question of issuing any show cause to the petitioner before refusing the renewal of the license, in as much as the initial license has already been expired much prior to the filing of the application for renewal of the license. This is very important, Lordship. What my friend is saying that I have to pass a speaking order, I should have given show cause prior to taking the decision. It is not a case of suspension. Had the case of suspension, had his application been rejected during the validity of the license period, then suspended and refused. Now it is not a case of suspension because he has applied after the expiry of the valid period. Now it may also be mentioned that in accordance with section 15 of the Arms Act, the provisions of section 13 and 14 have been made applicable for renewal of license, and there is no provision for issuing any show cause notice either under section 13 or section 14 of the Arms Act. Although, Your Lordship, we do not find any merit in the submission of learned advocate for the petitioner, and the brief statement for reasons was not furnished to the petitioner, because he also raised the same issue, that I was not given show cause, I was not given the reasons for refusing to renew my license. Same had been happening in the present case, Lordship. Another judgment, Lordship, here 2014 SCC online. This is also from Bombay High Court, Lordship. Page number 4647, Lordship. 2014 SCC online, Bombay 4647. The relevant para would be, Lordship.
Where is it?
Sorry, Lordship. Para 2, Lordship. The facts of the case, Lordship. The grievances of the petitioner is that by order dated so and so, the competent authority, additional district magistrate Hingoli, has refused to renew the arm license obtained by the petitioner in 2007, bearing number so and so so and so. This the same came to be rejected by the interim judgment dated so and so. That is the brief history. Now, Lordship, here, Lordship, para 6. That learned AGP appearing on behalf of the respondent has filed an affidavit in reply. It is specifically mentioned that the license of the petitioner has never been varied, nor suspended, nor revoked. The application for renewable license has been rejected, and the license has not been renewed on account of justifiable cause. Pursuant to the application dated so and so filed by the petitioner, the additional district magistrate called for a report from the superintendent of police Hingoli dealing with renewable arm license. Pursuant to the said request letter dated so and so, the superintendent of police Hingoli, after conducting an inquiry, submitted his report dated so and so and informed the respondent number so and so that the petitioner has been involved in the offence under section so and so and so on so of the Indian Penal Code, crime number so on so was pending before the learned judicial magistrate so on so. It is in these circumstances the license has not been renewed. The in-pin order dated so and so clearly makes a mention of the report received from the Superintendent of Police, Hinguli. It is gathered from the report that the crime registered here in the in-pin letter lordship, in-pin order lordship, we have mentioned saying that you have been facing a criminal proceeding before the court of so and so. That was the reasons we are not renewing the license. The in-pin order dated so and so makes a mention in the report received from the Superintendent Police, Hinguli. It is gathered from the report that the crime registered against the petitioner is pending adjudication. It is also noted that there are certain cases pending against the petitioner. It appears that from the said order that the concerned authorities are conscious of the facts that on account of pending cases and offences against the petitioner, misuse of the license cannot be ruled. Misuse of the license, armed license cannot be ruled out. By second in-pin order dated so and so delivered by the respondent number 3, similar circumstances emerging from the reports are considered, and based on the same, the authority concluded that it would not be fit and proper to renew the license of the petitioner until the criminal case pending before the learned so and so is decided. It is therefore emerged from the records that the respondent authorities have on the one hand declined to renew the armed license of the petitioner for the reasons mentioned in the in-pin orders, and on the another hand, the said refusal to renew the license is subject to the decision of the criminal case pending before the so and so. Needless to state, in the event the petitioner gets an acquittal and comes out clean from the pending criminal case, the respondent authorities would have no objection to consider his application for renewal of license. Here also we did not say that we will not renew. We said that till the outcome of the person, if you get acquittal or if the case is dismissed by the competent authority, then we will consider your application. Last para lordship, para 14 lordship. Having heard the submission of the learned advocates, having gone through the records and the provisions of the Act and the judgments cited above, I am of the view that the concerned authorities had applied for their mind to the case and have passed this being order. In the assessment of the respondent's competent authority, crime registered against the petitioner and the section of the Indian Penal Code invoked in relation thereto have resulted in the conclusion that the license of the petitioner ought not to be renewed until the criminal case pending before the learned judicial magistrate first class so and so Kalam Nuri is decided. I do not find any perversity or error in the in-pin order so as to exercise the supervisory jurisdiction of this court. The learned counsel for the petition submit that the case of the petitioner in writ petition is based on identical facts also. Here also did not consider lordship. The writ petition was dismissed, and same sets of facts in the instant case lordship. This is the last judgment, lordship. Here, lordship, this judgment talks about the provision of section 17(3), that variation, revocation and cancellation. Para 12, lordship. Although we are not on that, even in the case of variation, revocation, still the authority can take into account of the reports furnished by the police officers. That can be said that he is unfit for holding the armed license. Having heard learned counsel for the petitioner as well as the learned advocate general, we do not find any infirmity in the action of the respondent cancelling both the armed license. It is not in dispute that without disclosing about his previous armed license, petitioner had applied and obtain another arm license, even in the plea of ignorance of law, cannot come to the rescue of the petitioner. A specific column number so-and-so in application form requiring the applicant to furnish details of his previous arms license was deliberately kept blank by him while applying second time for the arm license. It was guilty of suppressio veri suggestio falsi. Respondents therefore justifiably exercise their powers under section 17(3) of the Arms Act in cancelling both his arm license. It is also worth noticing that the petitioner has applied for the firearm license for self-protection under some threat allegedly perceived by him in the year 2003. No material has been placed on records by the petitioner about existence or continuation of his threat perception as on date. In the facts of the case, even though petitioner's appeal against cancellation of his arm license number so-and-so is stated to be pending adjudication before the learned appellate authority, however, he, having approached this court seeking quashing of cancellation orders of both of his arm license after looking into and examining the cases, we have no manner of doubts that both the license deserve to be cancelled and were justly cancelled by the authorities. It was in 2013 that the authorities stumbled on the arms license records and discovered not only materials concealment of facts by the petitioner, but also the facts that many as 7 FIRs were registered against him. Some of these were registered even prior to the issuance of the first license. One of the FIRs were registered on so-and-so. As per the reports of the station house officers, so-and-so, the superintendent of police, the petitioner indulged in aggressive misconduct indicating threat to peace in the area. In the facts of the case, even acquittal of the petitioner in some of the FIR will not imply that he is not threat to peace in the area on the facts on police verification report. Here also, Lordship, the authority has invoked the power under section 17(3), cancelling the arm license based on the report furnished by the police officers. We are not cancelling his license. Here license is still active, Lordship, alive, Lordship. Only we have not renewed because of the pendency of the criminal cases, Lordship. Now what my friend has relied, 3 judgment, Lordship. One is 2016, Lordship. That judgment talks about, Lordship, revocation and cancellation. And judgment 18 also talks about issuance of fresh license, Lordship. We are here not issuance of fresh license. And even judgment of 22 also talks about cancellation and revocation of license already been granted, Lordship. So none of the judgment relied by my friends is applicable in this case, Lordship. The authority has invoked the power under section 15, although the power lies 14(3) for refusal to grant. This is the discretion lies with the authorities. And in the event if they refuse, there is no requirement to issue show cause notice to the petition because we are not cancelling the license. We just put on hold. If you get acquittal, we will consider your application. So, based on the submission, Lordship, I pray that the writ petitioner does not have any case, Lordship. The writ petition may be dismissed, Lordship.
I have just 2 points to address. Basic points.
Yes.
First, we may visit section 17 once.
Yes.
Lordship, section 17 says variation, suspension, and revocation. They have used 3 particular words here. Lordship, variation, suspension, and revocation, and these 3 words mean certain different things in relation to the act and certain different actions that have to be taken for achieving them. 17(1), Lordship.
Yes.
17.1 is the basic introduction to the 3. Now 17.2 is very independent when it says the licensing authority may, on the application of the holder of a license, also vary the conditions of the license. That is variation. 17.3, it's an independent subsection. It talks about suspension. The licensing authority may, by order in writing, suspend a license. It doesn't say vary a license. It doesn't say revoke a license. 17.4, the licensing authority may revoke a license. It doesn't talk of variation. It doesn't talk of suspension. And in any of these three cases, 17.5 says that the order has to be speaking order, application of mind has to be done. It quotes all three of them separately, Lordship. Especially subsection 1, subsection 3. Subsection 3 is the one where suspension comes into play. Now they are very, very cleverly trying to interchange these words and the meaning thereof. They talk of section 15, that is renewal of license. They read 15.3. They stop short of the last line, if I may, Lordship. 15.3's last line says, the provisions of section 13 and 14. This is something they stop. If I may read 15.3 in totality. Every license shall, unless the licensing authority for reasons to be recorded in writing, otherwise decides in any case, be renewable for the same period for which the license was originally granted. Unless for reasons to be recorded in writing, Lordship. It has to be renewed for the same period as it was renewed. And it says, and shall so be renewable from time to time, and the provisions of section 13 and section 14 shall apply to the renewal of a license as they apply to grant thereof. That means whenever a license is to be renewed, the provisions of section 13 and 14 shall apply as though this license was a new license which was being granted.
It is in the case of...
Let me complete, sir. Now, Lordship, this is the legislative intent. Now, my friend here is very cleverly, they are trying to use different fancy words. What does the order say? Admittedly, he is saying that order uses the word suspension, but it is wrongly written. We should not read it. That means the order in itself is defective. The order says the license will be temporarily suspended. Now, they might try to, because they have not followed the provision of this law. Their order says that it is suspended under 14 and 17. Can they give birth to a new section under which they'll suspend it? No, Lodge. 14 and 17 are the ones under which it is suspended, and 14 and 17 are the ones which embody the principle. And 15, which is a renewable clause, also says provisions of 13 and 14 shall apply as though every renewal is the process of giving a new license. So now they are trying to say, we will not say it is gone, the license is there, I am holding the license. What is the use of me holding the license if I cannot hold the weapons endorsed on it? Then they are saying that no, it is not suspended. It is something else but suspended. What is it? And Lordship, they will have to say the exact date, when did I put my license for suspension, for renewal. They have the records. They are not saying that. Hypothetically, they will say anything. But what paper says is my license is suspended under 14.3 and 17.3b. For me declared to be unfit, and for me also declared to be somebody who is a threat to public peace and security. Now, Lordship, I will conclude. This is a small gist of my written argument. And the compilation which have been given, if we can only glance para 10, I'll rest my submission on it. Page 4 of my compilation, para 10. Lordship, I am not saying his judgments are right, my judgments are right. We have to see the principle as laid down, interpreted, and how it suits. Lordship, para 10 says, page 4, para 10. This would be, Lordship, 2016 SCC Online, Bombay 5019.
Para 10.
Para 10, Lordship. If I may, Lordship. It says, it is significant to note that subsection B of subsection 3 of section 17 authorizes the licensing authority to cancel or revoke the license for the security, not to vary, Lordship, for the security of public peace or for public safety. The provisions indicate that in case the licensing authority is subjectively satisfied that in a given case, if the continuation of license endangers public peace or public safety, then the licensing authority is empowered to cancel or revoke the license. In the present case, the licensing authority had exercised the said power. The show cause notice refers to cases right from 1991 to 2006. Show cause notice, Lordship, requirement which was given, and 3 cases of preventive action taken against the petitioner. The licensing authority had also observed in the show cause notice that the registration of criminal case indicated that the petitioner was a criminal mindset. It was further observed that the law and order problem was likely to arise. The licensing authority was of the opinion that due to the law and order situation and danger to public peace, the license granted in favor of the petitioner was required to be cancelled. Lordship, what does it say? It says that I had several cases pending. A show cause was given to me. In that it was mentioned I had committed acts. Even the judgment my friend has relied upon, the last judgment, it says that I was of an aggressive nature. I have committed certain acts in public. And I have given birth to a situation where law and order problem might arise. Or I might be an accessory to it.
Lordship, what my friend section 17, section 15 referring, that 13, the renewal. So far as renewal of license is concerned, the same principle will follow as per section 13 and 14. Lordship, the 15 did not say so far as rejection of renewal of license that the principle of 13 and 14 will be.
You will, what do you do? Have you filed your written?
No, Lordship.
He has already prepared his, you should have prepared.
Then I'll
Lordship, 15.3 actually says unless otherwise.
I've heard the parties.
Lordship.
Can you do it by tomorrow?
Pardon, Lordship?
Do it by tomorrow.
Tomorrow, Lordship, I have one matter, Lordship, the part had matter before your Lordship, so that is also directed to submit the written submission. Lordship.
So 1 week then. Do it.
Lordship, in that case, I also humbly pray, since my gist of argument was what I have argued, not what I have countered to what my learned friend has said, I can file an additional, it may be reflected in that. Lordship.
Or you can take it back and file a comprehensive one.
I'll do that, Lordship.
Then counsel for the parties. On conclusion of the hearing, the parties have, then counsel for the parties have submitted that they may be allowed to file brief written synopsis of their written argument. We allow. This is matter for 1 week.
Obliged, Lordship. I'll file it prior to 1 week.
No, that's, but you can do it in the meantime, exchange it. If there's any response to the argument of the other party, then do it.
Obliged, Lordship.